Good morning and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute your cell phones or any electronic devices that may disturb this morning's argument. Thank you for your attention. We'll be starting shortly. since having business before the Honorable Chief Judge and Associate Judges, now presiding over the District Court of Appeals, draw near and give your attention. God save this on the court. This on the court is now in session. Please be seated and come forward.
Well, good morning and welcome to the District of Columbia Court of Appeals. We have a very full house today. We have a number of our summer law student and college student interns who are here with us today. So I'm just going to ask them to wave their hands in the air and welcome. We have we have one special sitting now and another special sitting to follow. Our first case is MH versus United States. Are parties ready to proceed? And I should say, for those of you who are new here for the arguments, I'm Chief Judge Blackburn Rigsby. I'm joined today by Associate Judge Corrine Beckwith and Associate Judge Roy McLeese. So.
Good morning, Your Honors. May it please the court. Paul Maneri on behalf of Appellant MH. I'd like to reserve 3 minutes for rebuttal. My plan today is to focus on 3 points in the following order. First, the evidence of SB's prior gun possession served no legitimate purpose and should have been excluded. Second, none of SB's texts to EB were so individually incriminating that they could be admissible as statements against penal interest. And third, these errors were not harmless, and reversal is warranted because the government used both SB's text messages and the evidence of his prior gun possession to bolster the notion that SB was, quote, a killer who credibly confessed and incriminated MH. I'd like to begin with the erroneous admission of the evidence of SB's prior gun possession because I think it's the simplest issue to resolve given how little dispute there is between us and the government on this point. Our only real disagreement is whether SB's gun possession was admissible on the theory that it corroborated his confession to EB. That was not a basis for admissibility in this case because the only way that SB's gun possession corroborated his involvement was through an impermissible propensity inference. As the DC Circuit explained in United States versus Bailey, quote, if similar past acts were corroborative only because they showed the defendant's character and the likelihood of action in conformity therewith, plainly, Rule 404B would call for exclusion. The government has never argued that SB's prior gun possession corroborates his confession by proving legitimate factors like intent or identity. And the only reason that the gun evidence was corroborative was because, as the trial court found, it showed the type of person that SB may have become.
So doesn't that make it even further attenuated? Because the theory that you assert the government admitted these evidence for was to show that SB was gun wielding based on photos, and SB and MH, the appellant here, were friends, and therefore MH had a propensity to be around people who were gun wielding or to be gun wielding himself, and therefore that made it propensity evidence.
No, so I mean, I think that is part of the harm, but I think it was propensity as to SB. It was proving SB's propensity for violence and SB's character, and as the prosecutor told the jury, proved that SB could be a killer. And that was prejudicial to MH, regardless of whether it reflected on MH's propensity or character, although it did, because of the nature of the way the government presented it.
Isn't there an argument that, relevance is a really low bar? And I mean, I think our case law is kind of all over the place on this, but why isn't it the case that just the evidence of SB having a gun shows he's a gun guy, he's comfortable with guns?
I mean, shows that he's a gun guy is his propensity. That's character evidence.
How about the strand of thinking in the government's brief, which is more access to firearms and you could think of that, I guess, as a mode of a non-propensity aspect of corroboration, arguably, or you could just think of it as his own line of thinking, non-corroborative, but just if the question is, did person A commit an offense with a particular instrumentality, even if you can't show they had that exact one, if you can show that in the past they had instrumentalities of that kind, they apparently know how to get them or previously had them. That's the government, I think, argues, in this court at least, that that's a non-propensity line of thinking. What's your response to that?
So I don't think that the government is arguing the traditional Johnson type evidence that a person possessed the instrumentality of a crime.
Precise, for sure, the exact instrumentality, they're not arguing that, but the type, in
Right.
other words, just,
And I think they would have to argue that, I guess, to more directly answer your question, in order for this not to be propensity. And that's the rationale of the cases from the federal courts of appeals that we cite in our reply brief, that absent some connection, and it doesn't need to be exact, but absent at least some proffer that there is a connection between the guns previously possessed and the guns possessed during the charged offense, the only real relevance for showing someone's prior possession of guns is propensity.
And why is that? I mean, let's take it out of other crimes, and let's say that a murder was committed with a plumbing wrench, possession of which is not an offense. And so, and let's say that the government wanted to introduce at the trial evidence that, a couple of years before, or a year before the murder, or 6 months before the murder, the defendant had been seen not with the murder weapon, but with plumbing tools that included wrenches that were similar in character. And the argument would not be, well, this is someone who has a propensity to carry plumbing tools and you should hold that against them, but instead just kind of relevant information that tends to show that the person had access to similar instrumentalities and knows where to find them and all. And so it does seem to me that you can ascribe maybe not a very strong amount of non-propensity relevance, but it doesn't seem to me it is intrinsically a propensity line of thinking.
I think where the instrumentality is in such common use as with plumbing tools or as with a handgun, and there is no more specific proffer about the previously possessed instrumentality and its distinctiveness that would allow there to be some relevance other than this person had access to something that everyone had access to, it fails on purely a relevance basis. But I think that hypothetical sanitizes what actually happened because, as Your Honor noted, that's not a prior bad act, possessing plumbing tools. So here you have not only an absence of distinctive traits that would show relevance between the prior possession and the possession that's alleged during the direct offense, you also have the prejudicial impact of putting before the jury a prior bad act.
No, and your other point is that my hypothetical, it might have been different if the way the trial court had admitted this evidence was on such a theory, which is it has this minimal relevance, but that was not the theory of admission or the theory of its use. So I definitely take those points, but I just am a little unsure that there's no possible non-propensity relevance to this kind of evidence. It seems to me, and I certainly take your point that its relevance could be minimal or debatable,
Right.
But I'm just not quite sure that there's really no non-propensity line of thinking that could have been relevant here.
I think as to that point, I would again point Your Honor to specifically the Third Circuit's decision in Williams that we cite in our reply brief, where they say, gun possession is not a distinctive act, and where the connection is merely access to generic guns with no proffer that the previously possessed guns were in any way connected to the charged offense, that's just propensity evidence. But I think that Your Honor makes an important point, which is that we could abstract, and I don't concede that there is a non-propensity inference to access to guns, but even if the court could conceive of such a purpose in the abstract, it's not this case, right? The government, far from arguing that, argued to the trial court that Drew and Johnson just don't apply when we're talking about prior bad acts of someone other than the defendant. And so the trial court admitted the evidence of SB's prior possession of the guns.
I just want to make sure I understand the meaning of the word "so" and what you just said. It is definitely true that the United States argued in what they now acknowledge as an incorrect argument that the other crimes doctrine didn't really apply to people who are other than the defendant. But when you said "so," it seemed to suggest that you thought that the trial court had admitted the evidence on the theory, agreeing with the government's theory, and I hadn't understood that to be true. But or do you think that's opaque? Or
I think
what?
that's a fair I agree it's not explicit. I think that's a fair reading of what happened, because when the trial court is confronted with a similar argument of MH's prior gun possession about a month before the shooting, and the government says all we can proffer is that it was a handgun, the court says, yeah, that's not coming in under Johnson, sorry. And so I think that the court, whether expressly or not, was at least influenced by the government's erroneous argument that Drew and Johnson don't apply. And whether it's so or then admitted this evidence and said the purpose for which she was admitting it was to show the type of person that SB might have become.
Right,
And
but
then
doesn't she also admit it to corroborate in part EB's statements? Was that a reasonable purpose for admitting these statements? The trial judge says that they corroborate and sort of bolster to some extent EB's statements.
they certainly did bolster, but that's not enough. And that's where I would point the court back to the DC Circuit's decisions in Bailey and Linares, is that corroboration is not a standalone basis to admit prior bad acts. The corroborative value has to depend on a legitimate purpose. And so just because this evidence was corroborative, the court said how she thought it was corroborative, which is that it showed the type of person that SB might have become. And that's an impermissible propensity purpose. And then again, the government sort of put the final nail in the coffin in one of the last things that they told the jury, which is that, look at this evidence, it shows that SB could be a killer. And I think whatever abstractions we could talk about up here about how the evidence might have been legitimately used, at that point, it's certainly being understood by the jury with no curative instruction or limiting instruction that they should consider it for SB's
Can you
propensity.
talk a little more about how that harmed MH?
Sure. The primary way in which it harmed MH was that SB's credibility as an out-of-court declarant was crucial to the prosecution, and the government concededly had no other evidence to corroborate that SB was the person in green. And I think it's really important to note that the only person who actually heard this really incriminating statement from SB in March was EB, and she tells the jury, I didn't buy that. So I think it's the jury would be
You're
left
talking
to wonder.
about the incriminating statement where SB says, essentially, I'm not using his same words, that he and MH killed somebody or.
Correct. Which would be devastating evidence to MH. I mean, that devastates his entire misidentification defense if the jury believes it. But I think they have good reason not to believe that when the only person who heard those words were a close friend who knows SB well and tells the jury, I don't buy it. And so the prosecution realized that and expressly told the court when arguing why the photos of SB with guns should be admitted and said, we don't have other evidence that SB was the person in green. We need to corroborate EB's testimony, and we're not going to be able to do that. So we need to bring in this evidence to be able to tell the jury that SB was in fact the person in green.
The government falls back on the strength of their case generally. And, there are 3 eyewitnesses to the crime. And there are 3 eyewitnesses who have a lot of flaws for sure, as you argue well in your brief. But there's still 3 eyewitnesses. And, can it really be a coincidence that 3 separate people implicate the same person in a crime in the way that these have and not have that take a serious, hurt your harm argument?
A couple of points. I do want to get to why it could be a coincidence and the flaws of the eyewitness testimony. But first, I want to start by saying that I think it's impossible to separate out the harm from bolstering the credibility of the confession from the rest of the government's evidence, because I think that the EB's testimony about the confession and the eyewitness testimony are actually connected. As I said, a confession from the person that the government has accused alongside MH is incredibly devastating if believed. The government put a lot of emphasis on that. And so I think if the jury has some doubts or questions about the eyewitness testimony, they can sort of not really worry about the problems with that testimony if they have a confession that they feel is really rock solid. If you sort of weaken the foundation of the confession, if you allow the jury to consider that evidence as it should have been considered without the bolstering from the propensity evidence and the hearsay text messages, which I do still want to get to, then I think the jury's attention naturally has to shift away from the confession and back to the eyewitness testimony, where the government's case has a lot of problems. And to your Honor's point about what are the chances that 3 separate eyewitnesses, I think First of all, you have to remember that there's two buckets of eyewitnesses. You have the two people who were direct eyewitnesses to the chase, Mr. Tribble and Mr. Phelps, and BL, who does not see anything about the chase. And she testifies that she sees MH sometime after she hears gunshots. And the timing of that, I think, is an important fact that's in dispute. Mr. Phelps did not identify MH until months later when he was subpoenaed to the grand jury. Mr. Tribble, who is the only eyewitness who contemporaneously, after having seen the chase and the person in black, identifies that person in black as MH. He testifies, though, that he'd only seen MH 3 times before. He couldn't get a good look at the person's face. The person was wearing a mask that covered all but their eyes. And so I think that is on its face sort of inherently suspect testimony. And then you add to that the fact that he's impeached during his cross-examination with the fact that during the grand jury, when the prosecutor showed him surveillance footage of that day and pointed to the person in black, Mr. Tribble said, actually, that's not MH. So I think, you know, the one eyewitness who identified MH on that day as the person in black who ran into the building had serious problems.
Well, but she also knew him arguably the best. This is BL. When she
Right, so
ran.
I was just talking about Mr.
Ran
Tribble.
it, is that the one you were talking about, or you were talking about?
I was talking
something?
about Mr. Tribble, who's the one who actually sees the person in black running into the building.
Well,
BL sees MH run into her apartment.
right, and
She
she
does not-
actually knows him the best. This is moments after the shots, and her credibility issue is her drug use, but I don't know how that negates the fact that she had known him for a longer period of time.
Certainly, but I think her drug use, her heavy drug use, calls into question her ability to perceive and to accurately recall and convey the details of what she saw and heard. And so,
Well, like what? I mean, it seems like it wouldn't make it hard for her to know that MH, who I've known for years, who's spent a lot of time at my house, came running into my house and he was out of breath. I have a hard time seeing how that drug use, maybe if she didn't know him as well as she portrayed, that might impact her ability to recognize him, but she clearly knew him and recognized him. And are you talking about the timeline at which she
I'm
claims he
saying
came
that
into her
DL
home?
had so many credibility problems, as the prosecutor put it before trial, she's quite impeachable, that the jury might have just looked at her testimony and said, we just can't really put any stock in that. But I think there's that, and then there's also the fact that the prosecutor in closing gets up and says, for the really crucial fact to BL's testimony, which is the timing of when MH comes into her apartment, don't rely on her testimony. It's not consistent with the rest of the evidence. In other words, it's not consistent with MH being the person in black. And so I think there's so many credibility problems with BL that it's hard to say whether the jury would have credited a single thing that she said. But also, if they did credit her, if they said, okay, she knew MH really well, what are the chances that she would have gotten it wrong that he ran into her building? It's just not that
Or
important for
into
the
her
government.
apartment, actually, right?
Right, but
Where he had been many times before. But I get that she had some impeachable issues, but her identification of him seems to be pretty solid. Now, I mean, it might have the timing issue. So I'm sorry. Go ahead.
separate from the impeachment issues, she identifies MH as coming into her apartment holding what she first refers to as a silver gun and then says black and silver. And the Mr. Phelps and Mr. Tribble both agree that the gun held by the person in black was just black. She testifies that MH ran into her apartment at a time that is inconsistent with the rest of the government's evidence of when the person in black would have run into her apartment if that is indeed what happened. And so I think you have two layers of problems with BL's testimony. The first is her credibility, and the second is that even if the jury is going to credit her testimony, there are exculpatory inferences to be drawn, and certainly it is at least consistent with MH's innocence because she is not putting MH at the scene of the shooting. And unfortunately, there was also testimony that gunfire in this neighborhood was extremely common. There were multiple instances of gunfire on that very afternoon.
Well,
So
but
even the fact that she
inconsistency
sees,
of between a number of eyewitnesses is not that unusual. is it, in these types of cases? So you do have three government witnesses, and so I take your overall point that, I mean, there's a question of whether the credibility issues of the three government witnesses, which the government then tries to bolster by the photograph. How does that cut in your case?
Right, so I think you have to go back to the harm standard, and the government has to be able to show that it is highly probable that the errors did not contribute to the verdict. And so part of that is whether the government's case was overwhelming. I don't think that the government's case was overwhelming for the reasons that we've described. But you don't need to think
The
that
one
the
reason
government's,
that you didn't mention is there was no other DNA or other
that's right.
was the actual gun ever recovered?
No,
Oh.
this came down to ultimately the jury determining the credibility of these three eyewitnesses and of EB and of SB, whose statements EB is relaying.
Because
And
EB
so-
was not present at trial, not alive. at the
SB
time of
was
trial.
not present at trial, that's
SB,
correct.
well, the initials.
There are a lot of initials in this
Mhm.
case, yeah. So, right, the government's case was not overwhelming, and then I think it's also really important to emphasize the centrality of the errors in the government's case and how important they were logically and how important how much emphasis the government put on the errors, right?
Do you
So,
want to go get to the text messages too? I know we.
yes, and then I will come
Briefly.
back to harm because I think that the cumulative impact of the errors was greater than the sum of its parts. So this hearsay text messages should not have been admitted under the exception for statements against penal interest. I want to start by talking about two clear legal principles that I don't think are really in dispute. The first is that under the Supreme Court's decision in Williamson, a statement must be individually incriminating in order to be admissible. So it's not enough that the statement is collateral to or related to other incriminating statements. It's not enough that it is situated within a narrative that is overall self-inculpatory.
But it was also somewhat artificial to not consider any context for a statement that's made. And so I'm not sure that the case goes as far as you suggest it does.
So Williamson, in talking about context, talks about looking to context to determine whether facially neutral but clear statements can be incriminating. And the examples that are given in Williamson all deal with statements that are clear in their meaning on their face and just you can't answer whether they're incriminating or not without looking to context.
I
So
mean, I get the idea of ambiguity, but on sort of individual consideration and context and the like, I mean, just to see if I can understand your line of thinking, because at times it seemed as though you thought you have to look at the statement not only individually, but also out of context and just look at it on its face without any further context, and it has to be incriminating, considered as a unit without any context. And I'm wondering if that's your position, and because I assume, let's say that you ask me a question after a shooting and you say, did you shoot the person? And I say, yes. Well, the word yes on its face without considering its context is, I mean, who knows what it means? So in order to understand whether it's incriminating, you have to understand what immediately preceded it. I assume you agree that that would be a statement against penal interest, or maybe you don't.
I'm not sure that I would agree that that's a statement against penal interest, because part of the rationale for this exception is that we can dispense with the usual concerns for admitting out-of-court statements, which are that they could be misunderstood or misheard or taken out of context by the listener, because it's inherently reliable when someone makes a clear assertion of fact that is so adverse to their penal interest that we don't need to worry about putting that through the crucible of cross-examination to test its reliability. Where the statement is simply yes, certainly in context that seems very incriminating, but I think that a lot of the rationale of 804B3 falls away when all that you have said as the declarant in that context is yes. And there are the sort of concerns with ambiguity and being taken out of context that are the whole reason that we have the rule against hearsay in the first place.
If you were going to try to point us to authority that would support the idea that this idea that you have to consider whether it's individually incriminating means on its face without regard to its context. It has to be unambiguously, as an isolated unit, facially incriminating. Is there a law that you would point to where courts have clearly said that? I mean, surely there's general language about it has to be individually incriminating, but I'm not sure that answers the question that we've been discussing about whether at the end of the day, you have to say, yes, that by itself is, that sentence is incriminating, but whether you have to assess that without the context in which it was uttered is at best ambiguous from the general language we've been discussing. So I'm just wondering if you have cases that take the position you're describing or reflect that line of thinking. Because I, off the top of my head, I wouldn't be aware of cases that take the idea that direction.
I think the direct answer to that question is I would point the court to this court's decision in Andrews. But before I get into the fact of Andrews and why I think that supports our argument, I do want to draw a distinction and maybe correct a misapprehension in what our position is. I don't think the statement itself needs to be on its face incriminating, devoid of context. I mean, that would controvert what Williamson holds. Williamson does hold that you have to, in order to determine whether a statement is incriminating, look to context. I think that's different, though, from looking to context to determine what the statement actually means if the statement is on its face ambiguous. So there's sort of two axes here, ambiguity and neutrality. And I would, as an example, point the court to all of the hypotheticals that are posed in Williamson, and in particular, the one posed by Justice Scalia in his concurrence, where he posits, if somebody says, I lawfully purchased a gun of X type with X ammunition, that is on its face neutral, and you have to look at context to determine whether it's incriminating. If the next statement is, and then I went and robbed a bank with that gun, the first statement, which is facially neutral, becomes clearly incriminating. But that first statement of I purchased the gun is not ambiguous in any way. The speaker's meaning is clear, and there's no ambiguity of what is being asserted in that statement. So you look to context to understand that
I have a hard time understanding. I get the abstract thought you're identifying, I think, but I don't quite understand how it would work practically in the following respect. So let's say I walk up to somebody and I say, I killed X. I mean, does that mean I just played tennis and won 6-0, or does it mean I shot them? Is it literal or is it figurative? I don't know. And so if you say you have to figure out whether something is incriminating without any context, you have to look at it and say it's incriminating. That's a pretty tough standard, and who knows what it means without context. That may not be the best example. I imagine if I thought about it more, I could think of better examples where things that in context would be quite incriminating and would no reasonable person hearing them would think otherwise, given the context, assuming that's the right context.
Well, what about the statements in this case, for example?
I think the statements in this case are in many respects easier than some of the hard hypotheticals that you can conjure up, because these statements are extremely innocuous. And I think,
like, for example, give me one statement that you think is innocuous that is from this case.
Is that his first charge? Nah. Where SB is clearly not even referring to himself. That can't be self-incriminating when
Unless you look at the sentence before and the sentence after.
Right, but you have to go statement by statement, right? And so I don't think that the government has articulated a basis for how any individual statement is actually against SB's penal interest, other than this sort of weak consciousness of guilt inference that because he is, quote, laying low, because he's, seemingly trying to avoid the police, that must show that he has a consciousness of guilt. And I think that really just cuts against this court's longstanding case law that, innocent people, just like guilty people, have all sorts of reasons to avoid the police. And so that can't be so clearly incriminating that no reasonable person would say it unless it were true.
I mean, I think the interaction between statement against penal interest and consciousness of guilt is very interesting, and there's a lot less law in it than I thought there would be. But let me just, imagine that, again, I walk up to you and I say to you, I shot John and then I ran from the scene and hid from the police. Those are my two sentences. Those are two sentences. I assume you would agree that the first of those sentences could be properly treated as a statement against penal interest.
Yes.
And do you think the second can't, because you have to consider it in isolation, and people could have lots of reasons, and I didn't say my reason was conscious of guilt. All I say is I ran from the police. I ran and hid from the police. That's the second sentence. In isolation, that's a conscious of guilt. That's a kind of ambiguous. So there's Supreme Court cases and cases of this court that say there's an inherent ambiguity. People have lots of reasons for hiding from the police or running from the police. So would you say that you'd have to admit the first and not admit the second in that example?
That's correct. Yeah. Because
And you would, I infer that you don't have to hand cases that would support concretely the idea that conscious of guilt type information in a larger statement that is an admission of guilt to which the conscious of guilt might logically relate have to be excluded, because I also haven't seen cases that take that form. Not to say I've seen cases that say that's wrong either. I just haven't
Right.
seen cases that directly address that.
No,
kind
I
of a
think Your
scenario.
Honor is right that our argument is based not on precedent that's on all 4 points, but on extrapolating from Williamson, which holds that the statement has to be admissible, or I'm sorry, against penal interest in its own right. It's not enough that there are other.
But
I get that line of thought, but it just seems to me ambiguous whether that means in its own right, meaning facially without regard to context, or whether it means you have to, at the end of the day, look at it and say, in its context, was that incriminating? So if it was some other thing that, was part of an inculpatory narrative, just because, because it's part of a general inculpatory narrative, you don't include it. That's the key part of Williamson for sure. But the idea that it must be incriminating considered by itself, meaning as its own assertion, I'm not sure necessarily presupposes the idea that in figuring that out, you can't look to any context, either, the other sentences that were around it or the situation in the world when it was made, all of that. That just seems like a hard, abstract way of looking at it.
I agree it's difficult. I think it's a difficult test to meet. I think that I didn't get to say the second principle that I think is important to keep in mind here, which is that not only must the statement be individually incriminating, it must be powerfully incriminating.
Well, powerfully is not our term or the Supreme Court's term, is it?
That's correct, but the government hasn't disputed that that is the fair reading of Rule 804(b)(3)'s text. I mean, the whole principle behind this exception is that a statement must be so clearly incriminating that no reasonable person would say that unless it were true, because reasonable people tend not to go around clearly incriminating themselves. I want to talk about Andrews, which is, I think, the case that best sort of captures how these principles work in tandem. And Andrews was a case where the defendant was a police officer who was accused of insisting on forcing a sex worker to perform sex acts after she had been arrested for soliciting. And the defendant in that case sought to admit another sex worker's statement that the two sex workers were trying to get the police to take the bait, and said that he understood that statement to mean that they were trying to bribe the officers. And the way that the court analyzed that statement was to say, the statement did not use the word bribe. So it's parsing the statement word by word. The statement did not say that the sex workers were trying to get the officers to have sex with them, and acknowledges that one possible interpretation of the statement is, yes, that these people who had been arrested were trying to bribe the officers to get out of the situation that they're in. But there is another possible interpretation, which is not that far off from bribery, which is just that they were trying to get the police officers in trouble. And what the court said was, because there are at least two possible interpretations of the statement, again, parsing that statement word by word, we cannot say that the declarant knew that she was clearly incriminating herself at the time she made the statement.
We went on and said more in a way that I think suggests correctly that Andrews was an easier case than this one.
Sure.
We went on and said, we have trouble discerning any clear meaning at all from the statement at issue, which suggests, I'm not sure I look at the text here, and if I'm allowed to consider the context in which they were uttered, I would say quite the same thing, that I just am flummoxed about attributing any clear meaning to them.
I mean, I think it's significant that in order to attribute any meaning to the text messages, you have to have testimony from EB putting into context what the text messages meant, which gets you back to the sort of concerns that I was talking about before, that you are now relying on another witness to say, this is how I interpreted these ambiguous statements, and you don't have an opportunity to cross-examine the declarant to ensure that the declarant was not misunderstood, that the declarant's words were not taken out of context. And I think if you just read the text messages, I mean, it's easy to imagine the detectives having read the text messages, gone to talk to EB, and she said, oh yeah, SB told me a story that his friend was arrested, and he was worried that he was going to get arrested too, even though he hadn't done anything. Right? The entire incriminating quality, to the extent that there is any, depends on EB saying, this is the lens through which I was viewing the text messages. And I think if you need that in order to make the statements incriminating, then they just don't fall within the test for Rule 804B3.
How much do you think age weighs into this analysis? It seems like the whole idea of the statement against penal interest rule is skewed when you're talking about teenagers making statements like this. You make an argument in your brief about this, but how do you think that affects the analysis?
I mean, I think that the statements were inadmissible regardless of the age of the speaker in this case, but I don't think that the court can do the analysis without taking into account the age of the speaker under all the Supreme Court precedent that says when we're talking about a reasonable person standard, you have to take into account factors like age.
Do you have are there any cases specific to this context?
I haven't seen any, but I mean, you have the court in cases like Miller and JDB saying that it's the rare case where there is not a sort of age analysis, especially when you're talking about reasonable person. And if the standard is whether a reasonable person in the declarant's shoes would have not said the statement because the statement is so clearly incriminating, then I think we have to assume that the reasonable person is a teenager with all the sort of inability to appreciate risk that is, clear from this court's case law, the Supreme Court's case law, legislative findings like IRA. I don't want to overstate, I think, the importance of that to our argument. I think that is just a sort of truism that the court needs to take into account when doing the analysis, but I think our argument would stand regardless of the age of the declarant.
All righty, thank you. I'm sorry, did you have?
No, that's fine.
We reserve some time for rebuttal for you, Mr. Maneri. Thank you.
May it please the court, Ann Park on behalf of the United States. I would also like to address the issues raised by Mr. Maneri and in the order that he raised them, and I would submit on our briefs for the remaining two issues. Beginning with SB's prior gun possession. At trial, the defense vigorously disputed or attacked the reliability and veracity of SB's confession to EB. Thus, any evidence that would corroborate EB's testimony regarding his confession was highly probative. Evidence of SB's prior possession of guns demonstrated that he had the opportunity to commit the charged crime, which made it more likely that he in fact committed it, and that the identification of himself on the surveillance footage as a man in green was true. If that portion of his confession was true, then it made it more likely that the portion of the confession identifying MH as the other gunman was also true.
So what's the theory here? Propensity?
The theory is it was admissible for the permissible purpose of corroborating SB's confession that came in through EB.
Right, but more concretely, corroborating through what line of reasoning? And you use the word opportunity, I guess. So is this a sort of access to handguns?
Yes, I think
He's charged with committing an offense with a gun, and evidence that he at some point had a different gun at least shows that he and guns, he somehow he knows how to get them. It's not opportunity with this particular weapon, but it's sort of generic opportunity along the plumbing tool hypothetical. Is that the line of thinking?
Yes, because there's no evidence that we can connect the guns in the photos, just although they do look black, they look like semi-automatics, but there's no testimony in the record about it at all.
And your opponent disputes whether that's a legitimate form of reasoning and is on its own terms. But I think your opponent's principal submission is that that's not how the evidence was admitted. It's stated the trial court's rationale for ruling, and it wasn't how it was argued in closing.
I would disagree, Your Honor, because I know there was some inartful language used both by the trial court in admitting the language and also the government in its rebuttal, I believe it was a rebuttal argument. But I think
Can we just talk about the word inartful? I mean, would you agree that the words that were used are propensity words? I mean, what was said, the trial court's ruling is, and this is a paraphrase, so, but roughly was in the nature of to show what kind of person he could be, and the trial court's, I mean, the closing argument is really in that same vein.
Yes.
So would you agree that the way in which it's inartful
They
is that
ring
they were
of propensity for sure.
You say ring, like,
Yes,
what-
I mean,
that sounds like it isn't, but it's,
But I think
in the
because-
reverberations out from it. Why is it?
I
not-
think because before they go into that line of, they talk about corroboration. And I think what unfortunately happened is they didn't go through the steps of explaining how it corroborated and why it was relevant in terms of helping them.
I
prove the
guess
confession.
the way it seemed more to me was that they had an incorrect theory about ways, it's at least arguable that this sort of access to firearms is a non-propensity use, and you could debate whether it's, that line of thinking is so attenuated that it be not an appropriate ground for admission. But if the way in which, if the mode of thinking of corroboration is, I want to show, I want to corroborate testimony that the child in green, I'm not going to get the initials right for sure, was actually a shooter who confessed to being involved in the shooting with MH. If the way I'm going to do that is to try to prove that the child in green is the kind of person who could be a killer, and that's, if you can't kind of wave your hand over that propensity line of thinking, call it corroboration and think it's admissible. I hope you'd agree.
No, I agree. And we're relying on corroboration. I'm gonna just point
Is
the
the
court.
corroboration an independent basis for admitting it, or is it a sub-purpose within the propensity realm?
In Jones, the court states it's not one of the classic Drew purposes. It's not in 404B, although opportunity is. But it cites the cases that where courts have found, including the DC Circuit, corroboration of a witness can be a permissible purpose.
And
to-
would you agree with the following abstract proposition? Although corroboration can be a legitimate use of other crimes evidence, it is not a legitimate use if the reasoning about why the other crime at issue is corroborative goes through an impermissible propensity line of thinking. Do you agree with that abstract
I
proposition?
agree if the corroboration is just really a front for pure propensity,
Well,
certainly.
I
But
front-
I don't
I
think that's what
the word
happened
front is a little
here.
ambiguous about whether there's a bad faith purpose, but I just mean, leave aside the word front, which so, I mean, you would agree, maybe, let's see, if the government said, we have a witness who says the defendant committed a crime, and we're going to put on other evidence of unrelated crime the defendant committed to corroborate that. And that's going to corroborate it because it will show the defendant is a criminal kind of person, and therefore you can believe someone who comes in and says the defendant committed the charged crime. You would agree that's not legitimate.
That's not a proper use of it. It's
Because-
calling it
because-
corroboration, but it's really propensity.
It goes through a propensity line of
Yes,
reasoning.
yes. But I'm just going to point the court to page 44 to 45 of the October 2022 transcript where the photographs were litigated and there's argument. Oh, I'm sorry. That's the defense opening statement. Hang on 1 second. Here we go. The government said when they objected to the first photograph, which is a picture of all three of them about a week before with SB holding the gun. It's 454.13, I think. Government said, we have to corroborate EB's testimony that SB was the second gunman based on a statement SB made to her. And Your Honor heard from her earlier this month. She was impeached. She was cross-examined. She testified at the statement against penal interest hearing that happened a month earlier. So a preview of her testimony had been heard by all parties in the court. This shows that she is telling the truth. When we have a picture of the defendant in association with SB and SB appears to be holding a gun. And this is at pages 10 to 11 of October 18th, 22nd. And that's the best, the rest of the arguments.
How
are
is it
corroboration.
showing? How
Yeah,
is it showing
doesn't go
that?
into it, but I think what we're.
Well, that's sort of the whole thing, isn't it? And if you're ending up relying on access to guns, is that?
Which is what he said later.
I mean,
with regard to other firearms.
where do you get the authority for that? The access to guns theory?
I read it. I mean, I know Mr. Maneri read it as a he had guns before, so he has guns this time.
Mhm.
I read it more access to guns is more as an opportunity, to commit the crime because he had the means
If that was,
available to him.
this picks up on something that Mr. Maneri said, but if that was the trial court's line of thinking, then why did the trial court exclude the evidence of prior unrelated gun possession by SH?
By M, by M.
I'm sorry, I knew I was gonna do MH.
I think the court, from what, she felt that any gun that you put in the defendant's hands that you could not link to the murder weapon was too prejudicial because he was a defendant on trial. That seems to be her reasoning. It was just highly inflammatory.
So you think
in
it
her
was
view.
a 403 balancing determination and not an other
Yes.
crimes determination?
That's my understanding. And defense counsel objected on all this to 403. I mean, it was all, he kept, the only objection was unduly prejudicial, unduly prejudicial. And I would point I know Mr. Maneri relies on Linares and Bailey, but I think those two cases are very, very different. In Bailey, it's an odd case because it's a drug case, but the 404, the government admitted two types of 404B evidence. One from the broker who testified as cooperator that he engaged in 7 to 12 drug deals with the defendant. And the second was 2 drug transactions that took place in New York, but the broker was not involved at all. And there, the government was trying to introduce the New York evidence, 404B evidence, to corroborate the 7 to 12 transactions, other 404B evidence. And the court was just like, this is too attenuated. And Linares, I think Linares is a true propensity argument for guns. In Linares, the defendant was convicted of felon in possession, but the court allowed the government to introduce that an officer testified that in New Haven, Connecticut, 4.5 years ago, he dropped the gun. The government tried to argue this went to motive, opportunity, intent, all these other permissible purposes. And the court was like, no, he had a gun 4.5 years ago. Your argument boils down to propensity. And that's not what's happening here at all. I mean, it's a little bit more, I understand I know this is a harder case than Jones, but it's definitely more attenuated than Linares.
So-
Because you have,
So
gun
let me
showing
just stop you
opportunity.
just briefly, just to
sure,
how I understand it being very attenuated and whether that makes it more admissible or less admissible. Because it seems like you're saying we're less attenuated here because the trial judge is admitting this photo to corroborate
The confession.
EB's testimony of what SB said about MH, even though the statement itself doesn't mention MH.
this statement does mention MH.
Which statement are we talking about?
The confession, we're talking about the in-person confession, March 2019.
Does he say me and MH? He says we got one,
Oh, that was a January
that
statement that was vague.
I'm confusing.
Yeah, and then there's a March in-person statement where he says, me and Leak killed
So he does use the
GW.
name.
And then he says, I'm the guy on the green, I'm in green on the surveillance video footage. You're talking about what came on news. And Leak is the young boy in black, the man in black on the
MH.
video. Yes, MH.
So
So he identifies both on the video.
we've got the statement under your theory being admitted to corroborate what EB says and SB says and what EB thinks it meant
Yes. So
about
it's
MH.
Yeah,
And
it's a little
so does-
confusing because.
Does that make it more admissible because it's more attenuated?
No, when I was using attenuated, I was saying Linares is to me like the classic propensity evidence of prior gun possession. You had a gun before, therefore we can introduce it to show you had a gun the second time. That seems to me pure propensity. And I'm just trying to say this case is not like Linares because we have in between, we have the defendant making these statements to his friend that he and someone else killed the victim and identifying himself on a video as the two people on the video. And the prior gun possession corroborates that he would likely have the opportunity to commit such a crime that corroborates his identification, which corroborates his identification of MH.
What do you make of I'm not sure it was the focus of your opponent's brief, at least the opening one, but, and I haven't checked the reply brief, but assuming that the theory of, we can't say it was the same gun used in the killing, but we can put a gun in the defendant's hand sometime before or maybe even after a killing that involved a gun, and that shows access to guns, which, shows generic opportunity in the sense of how to find them. Your opponent argued in the alternative, even if that's not an impermissible propensity use, subject to 404's restrictions, as we've not fully adopted the rule 404, but to the extent we follow it. But in any event, it is of little or no relevance and highly prejudicial, and therefore just is not a sensible ground of admission. What's your response to that? I mean, it's, sadly, as this case shows in a variety of ways, handguns are, extremely available. So what's the marginal significance of saying we can show that somebody can get something that seems to be readily available to everybody, and the way we'll do that is show they were committing a crime previously? It seems like it is of at least minimal, maybe less than minimal relevance, and pretty prejudicial. So what would the 403 balancing be like?
Your Honor, I think in those cases where it's just pure opportunity, I would say that the way that these facts are distinguished is you have the opportunity, but that you have it corroborating a specific confession.
I'm not sure why it would matter whether it's corroborating a confession or the testimony of eyewitnesses.
Well,
I don't see the
because,
logical relevance.
Jones, for instance, in like the evidence of a robbery in North Carolina, it confirmed like half of the confession that he had said to a jailhouse informant about the North Carolina robbery and the DC murder. So you can infer from the validity of the North Carolina robbery that the DC murder was correct. And ultimately that's what he was on trial for. So I just think I understand what your Honor is saying. Opportunity, and I haven't looked at the case law, but I can't think that it's so vague to mean general access to firearms.
What do you
I'm
think
not
it's proved here?
sure.
Could you be more specific about the way in which you think the evidence of prior possession of a gun showed opportunity? What do you mean by that, other than prior access to the category of instrumentality that was used in the offense? What more do you think opportunity would mean there in the sentence you were?
Your Honor, that's what I'm saying in terms of opportunity is prior access to the instrumentality.
The type of instrumentality that was
Yes,
used.
yes. He had the means to.
And are you aware of any case? Your opponent cites some cases that suggest that's not the right kind of evidence to put in. It's just not appropriate. It is too attenuated or improper or under Rule 404. Are you aware of cases that have upheld the admissibility of prior legal possession of a gun that is not the instrumentality, or is not being argued to be possibly the instrumentality of the offense, on a theory of sort of general access to firearms, and thus some evidence of heightened opportunity if you didn't know that someone at least somehow, somewhere once was able to find
No, Your
that kind of
Honor,
an instrumentality?
I'm not aware of those cases. There are a lot of cases that talk about if it's the same type of gun, revolver, semi-automatic pistol. So it does not have to be the same exact gun. But I'm not aware of those cases. And I think the difference in this case is that you're mediated by the confession itself, and relying on Jones and the DC Circuit's case in Bowie.
Before you turn from the propensity, can I ask you a question about an issue that MH raises in his reply brief? So MH raises a kind of separate argument about the prosecutor's statement, propensity-based statement and closing argument. And they say that the government has waived its counter argument to that claim by not addressing it in your brief. Do you agree with that, or?
Your Honor, I understand that's what they say. I think the rebuttal argument is all kind of wrapped up in the gun issue anyway. So we'd have the same arguments that we don't necessarily have to address it separately, because that's part and parcel of what he's saying, that this evidence was prejudicial to him, and it shouldn't have been admitted. But I'll note that although the government does make that statement, my recollection of the argument is it doesn't just say that. He's like, this evidence, he's responding directly to the defense counsel's argument in closing, where the defense counsel basically says SB is lying, he's fabricating, he's just creating an image for himself by saying these words, just like he did on social media with all those pictures of him with guns and drugs. This is not true. He's completely lying. So the defense counsel also said there's not one shred of evidence to corroborate EB's testimony about his confession. So the government comes back and says, no evidence to corroborate. Sure, here's evidence to corroborate. He had a gun. So, and he saw, EB testified that she saw him with a gun. He doesn't even reference the photos. He's just talking about the gun that she saw in January. And then he says that shows that the story is true. And that was part of it. And then he did mention that other,
But that is
other
a
part. Yes.
defense.
So I think it's part and parcel of it. And we would emphasize the corroboration part. And I know Mr. Maneri would emphasize the more propensity argument. But at the end of the day, I think if you read the defense counsel closing, he came hard at the confession. And that's why we think that this kind of evidence was important. It was highly probative. And I understand that it's kind of close to the line. It's not like Jones. Jones, I think, they had more details of the confession that were corroborated. And here we're just talking about a gun, but that's why it was admissible.
When
In
you
any
say
event,
this
it's
kind of-
harmless.
When you say this kind of evidence,
Oh,
how do you
okay.
define the evidence, the photo? You're saying it's not true, it's not propensity, you're saying it's just for relevance, therefore it's corroborative, or it's corroborative, therefore it's relevant.
I think
What
we're arguing.
category do we put
We're
this?
definitely saying it's relevant in light of the arguments that were made at trial. I mean, SB's confession was highly contested. It's definitely relevant. We're saying that it was admissible for the proper due purpose of corroborating confession. And we cite to Jones and the DC Circuit's case in Bowie. And we also argue that because it was so highly probative, it was not substantially weighed by any unfair prejudice. But any event, Your Honor, I think the easiest way to deal with this issue is to say really that the error was harmless. And I don't know if you want me to talk about the statements against penal interest and then talk about harmlessness first, or there was just a couple of points I want to make about.
Which era? The era of admitting the photo of SB with the gun, or what era? You said the error was harmless.
Oh, yeah, I'm talking about SB with the gun right now, and I can go, the evidence, the argument is basically the same for both. But I just want to make some points about the statement against penal interest, unless the court would like me to go into prejudice. The Williamson case, the way I read Williamson says, it doesn't say you have to go through a statement line by line. It says when you have a broader narrative where there's non-self-inculpatory parts and self-inculpatory parts, it's really important that you kind of parse through, because just because there's a non-self-inculpatory statement, it doesn't mean it gets in because the statement itself is generally inculpatory. We would argue here that the text message, there are no non-self-inculpatory parts. At no point does SB ever try to minimize his role in the murder. At no point does he try to, are there any self-serving statements or shifting the blame? I mean, I think Williamson and Thomas both are concerned about this parsing when you're talking about, broader narratives that have contained both kind of statements. And as for the text, I think if you read the text in context based on the March 2019 conversation, it's basically saying, SB is saying, I'm laying low. EB is telling him, you better stay down because he knows and she knows he's a second gunman that the police are looking for. I think that's what the statement boils down to. Now, I know if you go line by line, it's not what each statement says, but I think Mr. Maneri's argument goes counter to what people do not talk in a logical fashion all the time and get straight to the point. We certainly know that. There's a conversation that goes on, and sometimes you have to look at what comes before, what comes after, everything to understand what the point of the statement is. And so I just think the interpretation that Mr. Maneri is giving is just unrealistic. It doesn't really jibe with how conversation works or discussion works. In terms of
Just
harmlessness.
to make sure, I'm interested more abstractly, as I suggested earlier about the relationship between the ambiguity of conscious of guilt evidence and the requirements of the statement against penal interest doctrine, which seem to fit uncomfortably with a category of evidence that we acknowledge has ambiguity intrinsic in it typically. So do you think if the defendant is charged with committing an offense and the government wants to put in a statement that the defendant made, which is on the night of the shooting, I ran from where the shots were fired. Would you think that would be admissible as a statement against penal interest?
No, not unless there's more context filling it out.
And that's because people could run from a shooting for lots of reasons.
Yeah, I mean, I think the example you gave to Mr. Maneri, I shot John and then I ran from the police. I think that whole statement comes in because I think you can reasonably infer he ran from the police because he shot John. I mean, for me to be a very different hypothetical. I mean, I don't think you could just say I shot John. I mean,
And just to put another dot in between those, perhaps, imagine that a defendant is aware that there's a warrant out for his arrest for a crime and he's later charged with that crime and is on trial. And the government wants to introduce a statement that the defendant made that said, I was aware there was a warrant for me and I was hiding from the police. So then, unlike the first example I gave where it's a matter of inference why the fleeing occurred, the defendant is saying, I didn't want to be apprehended by the police. Would you say that's admissible or would you say that's not? You
he
think that
knows
is
he's
admissible?
wanted and he's evading the police. That's has to be some sort of criminal. He has to know that that's absurd. Yeah, I think that's admissible. Your
Well,
Honor.
I'm not sure it's a crime.
clear-
I'm not sure it's a crime to the police.
No,
It
not
might
a
be, I guess.
crime from the police, but he knows there's a warrant out for his arrest and he's actively trying to evade them.
Well, I think
I don't think that's something a reasonable person would admit to. I think it goes strongly against his interest.
it just seems sort of, I mean, again, people who have arrest warrants out against them might well hide from the police because they are guilty and they don't want to be apprehended. But it also might be that people who are not guilty would prefer not to be arrested by the police on charges. So it seems it has some ambiguity to it. And it's just a question, I guess, of how much ambiguity is fatal.
I think that's fair, Your Honor. I think your example, I shot John and I ran from the police, is probably the one that best supports our position. I think that's most like what's here, although it's not as straightforward because remember the story incorporates the confession, the earlier confession. That's exactly what's happening with the text here. And if I could just move to harmlessness, Your Honors, I apologize. It's doing so well. As Your Honor, Judge Beckwith pointed out, the crux of this case and the strength of the case, and we understand the witnesses had baggage, was the interlocking testimony of 4 independent witnesses. And then that was shored up by EB's testimony about SB's confession. And and I understand all the baggage that these witnesses had, but all that was aired before the jury, and they all knew that. And the issue is whether the admission of the text messages or these 3 photos, and I guess EB's testimony that she saw the defendant with a gun, did those errors substantially sway the jury's verdict here? And we would say no, in light of the strong evidence of the government. And also, EB, although defense counsel makes much of the fact that they needed the text messages and they needed the guns to shore up her testimony. I think the defense counsel, if you read his closing, he had tried in opening, he talked about how EB was not credible, how the statement was made 3 years ago. What does she's just telling you that, and that's all you're relying on. But at the end of the day, in closing argument, he hammered home the veracity of SB's confession. He did not focus so much on EB's credibility. And I think that's because EB, standing on her own, was a very credible witness. And her credibility and the veracity for repeating what SB told her lies in the nature of her relationship.
But
with
she may
SB.
have been credible in saying what he said to her, but that doesn't translate into the truth of what he said.
Yes, that's true. That's true, Your Honor. But I'm saying, I understand appellant's harmless error argument to be that EB's credibility needed to be shored up. So they had to put in the text messages where it gives, it's, remember the story, in writing, there's proof that there was some sort of conversation earlier between SB and EB where the confession took place. I'm just responding to what I believe appellant's argument is, and then that they need to put the guns in to shore up her credibility, to show that she wasn't making up the story, or wasn't a figment of her imagination. I think that those were the two ways that the confession and EB's testimony could be kind of undermined. I think what ended up happening is, if you look at defense counsel's closing argument, he relied basically purely on the veracity of SB's confession and not so much EB's credibility. So what I'm just trying to say is EB on her own, without the text messages, without photos of the defendant with a gun before at other occasions, she was credible because she was a childhood friend of SB. She did not live in the neighborhood. She didn't know any of the players. She did not know Malik personally. She only knew him through Instagram photos that SB had showed her. She was completely not above all this, but just outside of this whole world. And so I think that her credibility really comes from her close relationship with SB. And there's no reason for her to lie or make up the story that the defendant, the SB told her that he killed someone.
A story she didn't believe.
Well, she didn't, she said and that's what defense counsel argued. He said, you heard her, she didn't believe it, so why should you believe it? And I think the answer to that is, she said she didn't believe, in reference to the gun, she didn't believe he was that type of person. And I think at the end of the day, she knew him from elementary school as a childhood friend. It was hard for her to stomach that he could commit these crimes. And she says, she testified she didn't buy it, sure. But I think that's when the prosecutor used the gun. Well, she didn't buy it, but she saw him with the gun in January 2019. So, you know,
So as the
regardless of whether
prosecutor-
she believed
as
it
the
or
prosecutor
not.
put it, so he's that kind of person.
Yeah, that's what he said. But, you know,
You said, when you started this part of your argument, that all of the flaws of the eyewitnesses were aired before the jury.
Mhm.
Why does that matter? Isn't it the whole point of harm analysis one of the points anyway, to assess the strengths and weaknesses of the government's case? And if there are some weaknesses, it was aired before the jury, but it also is highly relevant to the extent to which, improperly admitted evidence might have shifted the jury.
sure, Your Honor. And I'm just relying on the Foreman case that we cite in our brief. Because in that case, you also had a harmless error analysis. The court found the erroneous admission of evidence was harmless, and they talked about how some of the witnesses, the grand jury transcripts came in. Some of the witnesses were high on drugs at the time. They all had baggage. And I think that the key is, when you look at harmless error, you're looking at what that jury, the jury who heard the case, would have done. Or how they were affected by the erroneous submission of the evidence.
So,
Did it substantially sway their
is the
verdict?
argument this jury convicted, therefore?
No. It's just saying that all the issues that appellants bring up, they heard it all, and yet they convicted. Would the photographs matter so
That
much?
could cut both ways, couldn't it?
Yeah, that'll always be true.
Oh,
Yes, Your Honor, but that's my understanding of, am I wrong?
No, it's just the observation that if the defendant is arguing the government is weak, the government's evidence is weak, but the jury didn't agree, it convicted. If that were a good response to a harmless error argument, I mean, that would always be available.
Yeah,
'cause
I'm
the
not
jury
saying
always-
it's
always
the-
convicted.
Yes,
It doesn't
I'm not
mean-
saying that's a harmless. I'm saying if you look at the error here, it wouldn't have substantially swayed the jury. It doesn't end at he was convicted, therefore the error is not harmless.
Can I
But you
push
look
back
at,
a little
would
bit
the
on that?
addition of the
Ms. Park?
photographs matter? And well, we
Sorry
say
to
it didn't
interrupt you,
matter.
Ms. Park, but I
Sorry.
just wanted to push back a little bit on, if the jury had already heard from the witnesses and heard about their credibility issues and challenges, you seem to be arguing, therefore, if the evidence of the photo and the text messages were wrongfully admitted to bolster EB's testimony, then what? I'm I guess I see it as that undercuts the government's argument that this was harmless error, doesn't it? Because if they were, you seem to be suggesting that they already accepted these witnesses and their testimony, the 4 witnesses or 3 witnesses of the government, faults and all. Therefore, it doesn't matter that you had this other evidence bolstering EB's testimony with the photo and with the text messages. And I guess one could argue just the opposite, that if they knew of the frailties of the government's witnesses, then this other testimony that comes in and bolsters EB's testimony about SB's confession and the photo could be viewed as tipping the balance in favor of a conviction, couldn't it be?
Well, Your Honor, that's why we're arguing that EB's credibility on its own, because of the nature of their relationship, was strong. It didn't need to be corroborated. She had absolutely no motive to fabricate and say that, this is what my very good friend, who has since passed away, told me. Absolutely no motive to fabricate. And as well, she really was not involved with any of the people in the neighborhood or the players. And based on that, we are saying that no bolstering was needed, and that the error was harmless. And I would just like to leave the court with the closing arguments of the government. And I know a lot has been said about the rebuttal argument, but at the end of the day, at the very end, the last page of his argument, it's on page 174 of the October 31st, 2022 transcript. He basically says, we have given you 4 witnesses who implicate directly this defendant in the shooting, and he names them. And it's completely unreasonable, I would submit to you, that all 4 of these people who implicate this defendant are lying or got it wrong. That is unreasonable. He closes and ends with these 4 witnesses and their interlocking testimony and the way they kind of corroborate each other. And that, at the end of the day, was the crux of the government's case. And that is, at the end of the day, is what the government ended with in its rebuttal argument. For all these reasons, we'd ask that the court affirm the conviction of the Superior Court. Thank you.
Thank you. All right, Mr. Maneri, I think you reserved 2 minutes, 3 minutes.
I thought it was 3. 2 brief points on the propensity issue, and then I want to address harm very briefly as well. I think, as Judge Beckwith pointed out, the government has waived any argument that the prosecutor did not make an improper propensity argument in its rebuttal. We asserted it in our brief at page 41. That was a separate error unto itself. And it's a completely separate issue whether the evidence could have been admitted theoretically for some non-propensity purpose and whether the prosecutor did in fact use it in a propensity way. The government did not respond to it. And I think that their arguments here in this court are telling that it rang of propensity, that the prosecutor did in fact say this shows that SP could be a killer. So the first point is that they waived that. The second point on the whole question of whether generic access to guns could potentially be a sort of non-propensity rationale, I think that would do a lot of violence to this court's doctrine, which requires some sort of non-conjectural, non-remote connection between prior possession of the instrumentality of a crime and the possession during the charged offense. It would make no sense for the court to require, as it did in Williams, which we cite in our opening brief, that the connection between the previously possessed gun be close in time and that the descriptions of the guns matched, if all the government needed to show was this person has had access to guns before, they therefore could have access to guns again. What I've just described to you is a propensity logic, a propensity inference, absent that specific connection that this court already requires in its case law. It's just propensity. So that brings me to harm. And I think the government made an extremely important concession in its argument right now, which was that the gun evidence was very important to the jury's assessment of SB's confession, which was hotly contested. I think they've misstated our argument, that our argument depends on EB's testimony being not credible. That is part of our argument, and we argue that the text messages were prejudicial because they bolstered EB's credibility. But we make the separate argument, and I think this is laid out most clearly in our reply brief, that even if the jury credited every single word of EB's testimony, there's a significant problem for the government because, as Judge Beckwith noted, EB told the jury, I didn't buy SB's story that he and MH killed GW. So the jury has no evidence apart from EB's testimony that SB was the person in green and that therefore he could be believed. And it's telling that the very first thing that the prosecutor says, as soon as he stands up to rebut the defense closing, is look at SB with guns, he could be a killer. That goes to the very heart of the case. There's no reason that the prosecutor would stand up and make that the first thing of his rebuttal if it wasn't extremely important. This is not a case where the prosecutor said, don't worry so much about the confession. We have these 3 strong eyewitnesses. I think the fact that the prosecutor is drawing the connections between the eyewitnesses and the confession is also telling. The prosecutor could have said, you know, yes, we haven't really presented you with a whole lot of evidence that SB was the person in green, but it doesn't matter because we have these 3 confessions. That's not how the prosecutor tried this case. They said you have to consider the evidence in its totality. And because the evidence is interlocking in that way, when you look at the trial and all that happened, which you must, you cannot say that it's highly probable that the errors in this case did not contribute to the verdict. I think that's true if the only error that you find is the propensity error. Certainly, I think the hearsay text messages should have been excluded as well, and they make the prejudice even greater. I want to just end with the additional prejudice that comes from combining the evidence that was erroneously admitted of MH's prior arrest with the prior bad acts of SB that served no legitimate purpose. Because you now have the jury considering prior bad acts of both SB, who the government is saying could be a killer and therefore should be believed, combined with the jury hearing that MH has been previously arrested, I think the prejudice is even greater. The jury has nothing to think, but these are 2 kids who are part of a bad crowd, and that they can then overlook the weaknesses in the rest of the government's case, sort of give the government a pass because these are 2 people, and where there is smoke, there must be fire. That's not how we do fair trials. MH was deprived of a fair trial by the errors in this case, and for that reason, if there are no further questions, we would ask the court to reverse.
All right, thank you. We'd like to thank both counsel for your briefs and arguments. We're going to take a brief recess because we have a different panel, except for me, in the next case. So we'll be about 5 minutes or so, and then we'll begin the next case. Thank you.
This court takes a short recess. This court is back in session. Please be seated and come to order.
Right, good morning again. We are back with the panel in the second matter. I'm joined by Associate Judge Vijay Shankar and Judge Anthony Epstein, who's sitting by designation from the DC Superior Court. Our second case today is EMANUEL LEYTON versus United States. We have various counsel arguing for both sides in this case. If you all could just remind the court how you plan to divide your time, starting with appellants.
Your Honor, I think we were allocated.
I don't know if we could just, if we can just hear you.
Your Honor, we were, I think the court allocated us each 7.5 minutes. I was planning on requesting 2 minutes of that for rebuttal.
Okay, and Ms. Wang, were you gonna request rebuttal as well? Okay, thank you. And for appellees.
So the United States is taking 10 minutes and the district is taking 5 minutes.
Okay, thank you. All right, are you ready to proceed?
Yes, sure.
Your Honor, if it please the court, my name is Matthew B. Kaplan and I represent appellant EMANUEL PICON. I plan on focusing on the firearms issues in this case. Your Honors, the Supreme Court's decision in Bruin sets the framework for determining the constitutionality of firearms regulations. Bruin established a two-part test. The first part is if you look at whether, under the first prong, you look at whether the challenged regulation is covered by the plain text of the Second Amendment. If it is, the regulation is presumptively unconstitutional. It remains unconstitutional unless the government can affirmatively show that that regulation is consistent with this nation's historic tradition of firearms regulation. And I think it's clear, applying this test to the facts of this case, these statutes are unconstitutional, at least as applied to my client. Looking first at the first prong, I mean, clearly, in our view, the challenge regulations fall within the scope of the plain text of the amendment. They're regulations on the right to bear arms, and they apply to the people, and my client is one of the people. The Supreme Court in Heller tells us, quoting another case, they tells us specifically that the Second Amendment preserves a, quote, right of the whole people, old and young, men, women, and boys. Turning to the second.
Well, so counsel, let me, before we go to the second prong, so you're focusing purely on the text of the amendment in the first prong. But in Bruin, the court said the text in light of its history. And so what is your authority for the argument that we can't consider the history of the amendment with respect to the first prong as well? And I understand whether that means that we're talking about whether your client is not one of the people or some other basis, but regardless of that, why can't we look at the history of the amendment to determine its scope with respect to the first prong?
Well, first of all, the test that's laid out says you look at just the text in the first prong, but.
Well, correct me if I'm wrong, I'm pretty sure in Bruin, the Supreme Court said you look at the text in light of the history.
And I think that was focused most on the second prong, but I don't say that it's inappropriate to look at the historical, for example, definition of the people. And I don't think there's any evidence whatsoever that when they said the people, they only meant some of the people. And for example, in Heller, the Supreme Court explicitly said that the militia was a subset of the people. And at that time, under the Militia Act of 1792, anyone 18 years, all persons 18 through, with very limited exceptions, 18 through 20, had to belong to the militia, and they had to provide their own firearms. But the important point to get to your question on the first prong is, I mean, one of the reasons we know that 18 to 20-year-olds were part of the people is the Supreme Court has said that.
Okay, but then, I mean, if that's your standard, I mean, 5-year-olds were part of the people too, right?
I would agree with that.
Okay, so
probably, yes.
So you would say that under the first prong, we can't constitutionally prescribe 5-year-olds from having firearms under the Second Amendment?
Well, the Supreme Court has a long history of addressing the constitutional rights of minors and the modern era people under the age of 18. And it has said basically that.
But that just begs the question of why 18 is the line then that you're drawing. I mean, if it's either all for your argument on the first prong, it's either all the people or it's some subset based on the history of how the country considered the people back in 1791.
I mean, again, you know, the issue of persons under 18 and their rights is not before the court, obviously, in this case. But that said, the Supreme Court has a long line of jurisprudence that says, yes, minors, people under 18 have constitutional rights, but they can be prescribed in ways that wouldn't be appropriate for adults.
Let me follow up on that because you said this was an as-applied challenge to your client. Does under the second prong, does the Second Amendment permit the government to impose the current age of majority of 18 on carrying of firearms? So could the government say you've got to be at least 18-year-olds to carry a pistol outside the home?
Again, it's not an issue in this case, but I think probably the answer is yes. I mean, this 18 years of age is not something that was purely a creation of the modern era. Back in 1792, that was the age to join the militia. So I think there's there would be a pretty good argument that that's where the line should be drawn. The Supreme Court has said in other contexts.
And if some age restriction is consistent with the nation's historical tradition of firearms regulation, can or should we give some deference to the legislature's decision to set it at 21 instead of 18?
I don't think so, Your Honor. If you follow that logic, I mean, the government has some studies that say people through their mid-20s are potentially dangerous, aren't fully formed. If you follow that logic, the legislature could set the age at 22, 23, 24. Every other constitutional right we have is fully enjoyed, robustly enjoyed at the age of 18. If we say something different about the Second Amendment.
It wasn't, the right to vote wasn't robustly enjoyed in 1789 at the age of 18.
That's true, Your Honor, but I think
the right to vote is as fundamental as the right to bear arms.
That's true, Your Honor, but the age of majority has changed over time. And there's now a societal consensus, and the Supreme Court has said this in it's cases on the Eighth Amendment, there's now a societal consensus that 18 is the age of majority. And you've got to draw the line somewhere. And
But
a
that's not
logical
in the
place.
Constitution anywhere, other than perhaps the 26th Amendment, right? Which was well past 1791. I mean, where is 18? What's magical about 18 as a constitutional matter?
Again, we're not necessarily we're saying, I mean, this guy, an issue in this case is not what the minimum age is to own firearms. Our argument is that 18, 19, and 20-year-olds enjoy constitutional rights to own firearms. What I'm saying, I think an answer to your concern is that there is a well-established, it's very clear in the founding era that 18-year-olds and older had, in fact, they had to have firearms under the Militia Act.
But so now we're just battling about the history, which is, I mean, that's the whole point. But what we're saying is, if there is, or what I'm saying is, if there is history that suggests it was actually 21, and I know you disagree with that.
Mhm.
But your counter argument is just that there was history showing that it was 18, but there's nothing magical about 18, 20, 21, 23, 25 as a constitutional matter. You would agree with that, right?
Well, I would disagree in the sense that I think the Supreme Court has said, you're right, it's obviously not in the text of the Constitution, but the Supreme Court has said that that is the, certainly for Eighth Amendment purposes, that's the age of adulthood. And I think they made the very logical assertion that you've got to draw the line somewhere. And that's where they drew the line. I think there was support for that back in the historical record, back in 1792. And aside from that, there's now a modern consensus that is the age of adulthood. If you had a different position, you could say Congress could pass a law saying that, you know, no one who's 20 years old could criticize the president. And I don't think anyone accepts that proposition. And it's very difficult to understand why that would be, you would apply a 21-year-old age limit to the Second Amendment, but not to the First Amendment or the other constitutional rights guaranteed by the Bill of Rights. Turning this, we did a little bit to the second prong. The government, assuming we meet the first prong, the government needs to show that the challenged firearms regulations are consistent with the nation's historical practice of regulating firearms. And the Supreme Court tells us to do this. We look at founding era analogs, similar statutory or common law regimes that existed at the founding. The Supreme Court did this most recently in Rahimi. Here, even by the government's own admission, there are no analogous common law regulations of firearms. There were no regulations of firearms at the time of the founding. And in fact, there's not even any evidence that anyone discussed regulating.
Doesn't that just underscore the notion that there would have been no need or no consideration of such restrictions or regulations if the whole conception of the Second Amendment was that it didn't apply to anyone under 21 at the time? And that would be consistent at least with that, right?
I don't think so. I mean, one thing the Supreme Court tells us is that a societal problem existed back at the founding, and there was no regulation of it that suggests that, at least for Second Amendment purposes, that a modern regulation would not be constitutional. And certainly, I mean, the government in the district in the briefs talk about the founders discussing the impulsivity of youth. But despite that fact, which existed in the Seventh Day Concern, which existed in 1792, the founders did not impose, even apparently consider imposing, age restrictions on firearms. Now, it may be, there may have been sort of a common sense understanding that generally people who have firearms were 18 and older. We know 18-year-olds had firearms, and maybe generally people who were younger didn't have firearms. But that was a societal problem that existed at the founding, and which they did not regulate it and say any need to regulate that. So there's no
a long list of unchallenged regulations dating back at least to the 19th century, regulating firearm use by minors, use, possession, sale of firearms by minors. Are we able to take into account those? They might be slightly after the founding, quote unquote, but they are early regulations. during the early 19th century Reconstruction era and beyond, almost to the present, where there are regulations around the use of firearms by minors. Can those be considered when we look at this historical perspective?
I don't think so, Your Honor. I think they're too far in time. I think aside from two,
Well, we've had some cases that, Supreme Court cases that mention that perhaps that era could also be looked at, right?
you most notably in Bruin itself, the Supreme Court said that those had lesser weight, but it did look at late 18th century, late 19th century regulations on firearms. But the point the court was making there was that it was sort of a continuation of the same tradition. What was that issue, obviously, in that case, was the right to carry weapons. And they said there was a long tradition. You can find examples in the colonial era, the founding era, and all the way through the 18th century. Here, by the government's own account, it's not the same. There were no age-based restrictions whatsoever, and they didn't pop up until, with these two exceptions from states that were about to secede from the Union before the Civil War. They didn't start becoming commonplace until I think it was 1875. And as PDS discusses it in some detail in the brief, we don't think that really, there were very limited regulations on the purchase, regulations on concealed weapons, but most of those were not really comparable to the statute at issue in this case.
I mean, the rubber hits the road really when we talk about how analogous it needs to be, right? I mean, that's what Rahimi said. And so Rahimi seemed to rely on regulations that were not particularly on point with respect to the domestic violence regulations at issue in 922, section 922. I mean, the surety and going armed regulations are as the court put it, similarly relevant, but not directly on point. How is that different from what the government has provided here?
Well, I think the big difference between here and that case is there's no, I mean, you're right. I mean, they broadly interpreted some historical regimes to regulate firearms are fairly broadly interpreted, but they found it necessary to go back and find an historical analog from the founding era. I mean,
But I guess my question is, why does the analog have to pertain particularly to firearms themselves? I mean, if, and I'm not saying you would agree to this, but if there was, just a vast number of restrictions at the time that said anyone under 21 can't do A through Z, then would we need to find a specific restriction that speaks specifically to firearms as well?
I think you would, Your Honor, because that's what the Supreme Court says. You look at our tradition of firearms regulation, not our tradition more broadly.
Well,
But
they said
even,
it didn't have to be a twin.
No, it doesn't have to be twin.
Legislative twin, it could be an analog similar. Like, for example, the restrictions on minors who were attending universities at the time.
well, I think is, I mean, the government mentions that, and that's the closest they can come to an analog, but I don't think that really carries any weight. I mean, obviously, those weren't laws. They were restrictions on what people at school could do that weren't restricted to minors generally. And they come, several of them come from, and maybe all of them come from several decades after the Second Amendment was implemented. So I don't think those carry any, I mean, they simply weren't laws. But there were restrictions on minors' ability, most notably to contract. But those were meant to protect the rights of minors, not to take away their rights. And the government's right. Parents had a lot of authority over their children, over people up to the age of 21 in the colonial era. And it's certainly possible that a parent could have said that, my son can't have a rifle except for the fact that he was obligated to by the Militia Act. But assuming the parent could have said that, it does not follow that the government can say the same thing. I mean, the fact that a parent can restrict a child from having something is not, I mean, the Second Amendment applies to the government. It limits
But
the
I mean,
government's
yeah, but if the reason why the government sees fit to preclude something is really a secondary question, right? That presumes that the government has the constitutional right to do so. So if the government says minors, whether that's 21 or 18, that's the second question, but can't enter into contracts, whether it's out of some sort of protective mindset or a different mindset, doesn't really matter, because we still have to assume at that point that the government believes the Constitution gives it the right to restrict that right. So what difference does it make what the purpose is?
I mean, I think it does. I mean, the Supreme Court says you look at the how and the why of regulations, and the why of those regulations was to protect the rights of minors, particularly make sure their property wasn't stolen. And there were classes of people, most notably Black Americans at that time, who probably were considered totally outside of the Second Amendment or the other protections and did not have any rights. And the government seems to sort of equate people under 21 with that group of rightless individuals. I don't think that's right at all. The minors, people under 21, had rights, and the legal regime was meant to protect their rights. It wasn't meant to allow the government to come in and, for example, take away their property, take away their firearms.
All right, Mr. Kaplan, did you want to reserve your remaining time for rebuttal?
Yes, Your Honor.
Okay, thank you.
Your Honors,
Good
Alice
morning.
Wang on behalf of the Public Defender Service as amicus curiae. I'd like to reserve 2 minutes for rebuttal. I'd like to focus on 2 main points. First is the proper understanding of the text portion of the text and history test. And second is the lack of relevant similarity between the government's historical analogs and the district's complete disarmament of all adults under the age of 21. The district
Well, except if they get permission from a parent or guardian under our regulations.
the law actually requires them, prohibits all carrying of any firearm outside the home for self-defense. So you can possess a firearm in your home if you're an adult under the age of 21 and you get the permission of your parents who are no longer have any authority over you. You can keep it in your home, but you cannot carry it outside the home for self-defense because you can't get a license to carry it. So there's no you can't get a license to carry a pistol because it's just a flat ban on anyone under 21. And you also can't carry a rifle or shotgun because no one in the District of Columbia is allowed to carry a rifle or shotgun. So adults under the age of 21 have 0 Second Amendment rights outside the home.
Well, but the difference here is the prohibition on carrying weapons outside the home doesn't just apply to 18-year-olds. You're saying all adults, 18-year-olds on a.
Well, adults who are over 21 can get a license to carry a pistol.
How are you looking at the exception in the DC statute?
The DC statute says that anyone who wants to carry a pistol outside the home has to get a license. The licensing law says no one under the age of 21 can get a license. So no one under the age of 21, including adults under the age of 21, 18 to 20-year-olds, can get a license to carry a pistol. If you're over 21, you can get a license to carry. But if you're under 21, you can't get a license to carry. And you have to have a license to carry. So you can't carry a pistol if you're between the ages of 18 and 20. And then
No, I'm asking about the exception with parental consent.
the parental consent exception is as to firearm registration. So registration, you can register a pistol or a long gun for keeping in your home, but you can't carry it outside your home without a license. And so the registration provision says that you can register a firearm if you are under 21 but over 18, if you have parental permission and if your parent agrees to assume all civil liability relating to that firearm. So if you're 20 years old not living with your parents anymore, not under their custody and control, and you have your own home, you can't keep a firearm in that home unless your parents agree to it. And then even if your parents agree to it, you can't carry it outside the home.
Okay, now you keep saying adults who are under the age of 21.
Yes.
If you're looking at the text of the language in the Constitution.
Yes.
I don't know that this analog of adults now is the same as adults then.
Yes, I'd like to address that. So the Haller and Bruin both say that you use the original meaning of the text, but you apply it to modern circumstance. So Haller gives the example that the word arms is not limited to only those arms that existed in the 18th century. And the word people doesn't just mean the people who are considered people in the 18th century. You look at what are arms considered arms today. So for example, semi-automatic pistols were not considered arms in the 18th century because they didn't exist yet. But of course, they're the most commonly used weapon, in the United States for self-defense, and you can't completely ban them. And yes,
semi-automatic weapons are used.
Yes, semi-automatic handguns are the most common weapon used.
But are they used for self?
Well, Heller said they were. Heller said they were. So
I understand that.
or even and I don't think there's any doubt. I don't think there's any dispute or doubt that they would be protected arms today. The Supreme Court has held that they are. And by the same token, people who were not considered members of the people, although Heller does say all people, it says all Americans. It doesn't say any. Heller says people means all Americans, not some unspecified subset. But even if it did mean some unspecified subset, it wouldn't be white, landed, adult males over the age of 21. Those were the only people who were, sort of had political and legal rights at the time. That doesn't mean that they're the only people protected today. You look at who are the people today, who are the members of the political community. And of course, that would include people of all races, Native Americans, women, and people who are considered adults today. And I wanted to address the sort of question of why is 21 a magic number or 18 a magic number? It's not about magic numbers. It's about the status of adults versus children, because all of the rationale for restricting the rights of minor children who are under the complete custody and control of their parents, that, as the district states in its brief, their constitutional rights can be restricted in ways that adults could not, because they're always already under such strict restrictions under their parents. Like in the college campus.
So you agree then that the Second Amendment permits the district today to set the minimum age for handgun carrying at 18? So
I would agree. So I don't agree that it's because they're not part of the people. I think the plain text.
Under the second
right.
step.
But as far as the historical justification, I think that there's at least some evidence, which is that, the evidence that the United States cites from the 1850s on, that shows that there's a historical tradition of restricting access to dangerous and unusual weapons by minors. And I do think that pistols, I do think that does not justify disarming entirely, not just in dangerous and unusual weapons, but all weapons, that there's a big how problem there. But for sure, it doesn't mean that you can completely disarm adults, because that tradition is of restricting minors, not adults. Now, whether, the District of Columbia can restrict the rights of minors, that's not presented in this case. And I don't think this court has to reach that. I think they have a much stronger case of that, because there is a strong tradition of restricting the rights of minors.
But that just, yeah, we don't have to reach it here, but everyone's dancing around the fact that it relates directly to our analysis and your reasoning, right? And so let's go back to the first prong. And if you're saying the first prong has to be judged as of today, and you're saying it's all Americans, then that's everyone.
Yep.
Right? So are 5-year-olds protected under the Second Amendment?
They're part of the people, but you can regulate them if there's a historical tradition of doing so. And I
Right.
think there's a historical tradition of,
So then you're conceding that the line is just whether there was an historical tradition of regulating at 18 or 19 or 21?
no, I think that the question is whether there's a historical tradition of disarming adults based on age.
Yeah, but what's the definition of an adult?
And that the definition of adult is when actually, one of the cases cited by the government says that the definition of adult is not just somehow sort of, divined by age. The definition of adult is whenever the law recognizes that a person is their own legal person and no longer is under the custody and control of their parents and has legal responsibility and authority over their own lives. And that is up to.
What can you point to regulation wise?
Uh-huh.
I'm sorry, I didn't realize I cut you off. From 1791 that said 5-year-olds can't possess arms.
I agree that there's not a sort of use it or lose it situation where just because there's no law saying that 5-year-olds can't have guns doesn't mean that that people at the time wouldn't think that was a constitutional
Right.
restriction.
So that's the question that we
Yes.
have before us, right?
That is the question. And I think
So
that
if the district raised the age of majority back to 21, could it keep the 21 age restriction for carrying handguns?
I think that if we had a huge social change, the way that we did in the 1970s, where all of society thought, you know what, parents have to keep control over their children until the age of 21. They can't move out. They can't have their own jobs. They can't own property. They have to be under parental control until 21. Then yeah, they would be minors. And then all of the historical tradition of restricting minors would justify restricting their rights. It's not just sort of a legislative decision. We call it the age of majority. It is a societal recognition recognized by the law that once you turn 21, your parents have no authority over you. You live in your own house, you have your own job, you're responsible for your own life, and then you don't have the right to defend your own life with a gun.
But
If you're a
so
child-
counsel, if you accept, as I think you did, that, or not just accept, you posit that the people includes 5-year-olds. And at least your co-counsel said, and I think it was your position in the brief, that there were no restrictions based on age as of 1791. Then I know you were trying to answer the question, but can you answer the question? What today would constitutionally permit a government from saying that a 5-year-old can't possess a firearm?
So I think that you could look to the 1850s regulations that say that, or the college regulations. So for example, the college regulations, I think that's actually a very good example. The rationale, the why is that the colleges were acting in loco parentis and that they had just as much authority to control children as parents did. And so they could prevent children who were enrolled in their college to not carry firearms.
Some of whom were between 18 and 21.
At the time, yes. But they were considered children. And the rationale for the colleges being able to do that was they were acting in loco parentis.
So
that rationale does not apply to
When did 18
adults.
to 20-year-olds, under your analysis, move from being adults to being, move from being adults to being children? You're suggesting they moved backwards in time, that at the founding they were adults, but in the 1800s or
No,
during
they
the
were
time we're
always
talking
considered
about-
children until 1970.
Okay.
So from all the way from the common law until after the Vietnam War, basically, the 20-year-olds, 18 to 21-year-olds were considered children. They had no ability to have their own property. They had no ability to.
Your argument is that they were considered children at the time of the founding and,
Yes.
and then in the early 1800s.
Yes.
And although in one period in time, it would have affected their rights at a university, those who could go at the time. But at another period of time, it would not have had any bearing on their ability to possess firearms.
Which period in time?
Founding period.
The founding, the college regulations
No, I'm saying these are two different time periods. College regulation
Uh-huh.
period was after the founding period.
Right.
But I understand your argument to be saying that as children, 18 to 21 years old, during the founding period, there
Mhm.
were no restrictions on their ability to own firearms.
Well, they
No-
couldn't
no
own
restriction.
firearms because they couldn't own property. And no
so
one could sell a firearm
what's the-
to a
what's the
child.
distinction between ownership of a firearm, in your view, and the right to possess and use a firearm during the founding?
So during the founding, a child, there's nothing preventing a child from using a rifle to hunt. I think it was very common for children to use rifles to hunt, or even for parents to give, say this is your gun. But they're children, so of course parents are controlling the guns, and no one can sell a gun to a child because they can't enter a contract with a child. So there's really no reason to regulate. I mean, I agree with the government that just because nothing exists at the time of the founding isn't dispositive. I mean, the Supreme Court has said that. So I'm not saying that it's dispositive that in 1791 there were no laws restricting the rights of 5-year-olds. No one would think to do that because parents are responsible for regulating the rights of their 5-year-olds. And then in the 1850s, it became a problem that there were all these unusual and dangerous weapons: Bowie knives, dirks, daggers, sword canes, pistols. Pistols was one of them. It's a list of a collection of arms that you see in every statute. They're all the same. That the government has argued in other cases that those are unusual and dangerous weapons.
So then
And then
I mean, as you said, at the time of the founding, minors couldn't purchase firearms.
right.
The Fifth Circuit in the Reese case said rather persuasively to me that the right to keep and bear arms implies the right to purchase them, because if you're dependent on your parents' generosity in getting them, it's not much of a right. So then doesn't it follow that there is a tradition of regulating not only purchase but possession of firearms by minors at the time of the
If
founding?
you're a minor, yes, because you do have to depend on the generosity of your parents for almost everything if you're a child. But if you're an adult,
But then
That's not the
we're
case.
right back to what, it's 21 versus 18. That's all we're at. I mean, I don't mean this to sound rude, but can you just state your argument? Because I'm quite confused about
Yes.
what it is.
my argument is that the government has identified a historical tradition of restricting access to unusual and dangerous weapons by minors, and the how and the why are linked to the fact that minors are under the custody and control of their parents and naturally have diminished constitutional protection for that reason. For example, the Fourth Amendment allows a parent to consent to the search of their child, their minor child, but not to their adult child. And whether you're a minor child or an adult child depends on the age of majority. And that's why the age of majority matters. So if you're at the time of the founding, if you were 20, your parent could consent to a search of you. Today, they couldn't because you're not a minor anymore. And that's not just sort of an arbitrary age line. It's the line at which the law recognizes that
So
you
that
are your
might
own person.
that might support the people argument, which I guess is part of the first prong of Bruin. But the second part of Bruin is a test that is specific to the Second Amendment context. It's not a test that applies to the Fourth or First Amendment context. And so perhaps it would be unconstitutional to have a law that says people under 21 can't seek suppression of illegally seized items, basically depriving them of their Fourth Amendment rights. But the Supreme Court has never set forth a test that requires us to look at historical analogs from the 1790s for the Fourth Amendment. Maybe it could, but it hasn't done that. So for the Second Amendment, regardless of the Fourth Amendment situation, Supreme Court has told us, look back and see what was the history and tradition in 1791. And where everything seems to come down to is the government says it's basically 21. And
Yes.
Mr. Layton says, yeah, sorry, go ahead.
I have two responses to that. One is that the Supreme Court has already said you can't look at laws trapped in amber like that. So for example, it was Bruin said, even if it were the case that in the colonial times, handguns could be banned as unusual and dangerous weapons, that doesn't mean they can be banned today as unusual and dangerous weapons. You have to look at the rationale and the how and the why. The why has to be similar, relevantly similar. Okay, so if you take that principle, that just because it says handguns in 1600s or 1800, whatever, doesn't mean handguns today. It's just because they use the same word doesn't mean that it's constitutionally justified. You have to look at why they were banned. And if it were the case that in colonial times, handguns were banned because they were unusual, dangerous, then you ask, are they still unusual and dangerous today? And the answer is they're not unusual today.
Well,
Okay.
but the council has said in a different context that guns in the hands of people under 25 is unusually dangerous. I'm thinking of IRA and, because drew the line at 25, that if you're under 25, you have the hallmarks of youth, including impetuosity and all those things. So there is a context outside of restrictions on gun possession where our legislative branch has recognized that possession of guns, and I mean, almost all the crimes that end up with sentences of 15 years or more and, involve guns, that there is a special risk in the possession of firearms by young people.
That, I don't think that the unusual and dangerous framework applies to the unusual and dangerous conduct. It's about which kinds of arms are unusual and dangerous.
Fair enough.
And so let me just continue with my analogy, which is that you look at historical restrictions on minors, and I will point out that many, if not most of the statutes use actually the word minor, and some of them say 21, which of course was the age of majority. So it's, and there's not any other age. It's not as though legislatures were deciding what age is it best to restrict these guns, just like, you'd expect that if it was about age, then you'd see different ages, just like with driving, getting a driver's license throughout different states have different ages. They range from 16 to 18, some of them as young as 14. But the reason that they all pick minority versus majority, or they use the word 21, which is the universal age majority, is because the why for restricting minors was that they were children under the custody and control of their parents who have no legal authority over their own lives. That's the why. Yes, it's because they're dangerous, but also because you can restrict their rights more because they're minors. Then you ask, is that still true today? Just like when you asked, are handguns still unusual and dangerous? And that is not true today because universally 18 to 20-year-olds are not under the custody and control of their parents.
Okay,
They
but you
have
said
full-fledged constitutional
you said it was
rights.
both. You said it was custody and care of their parents and it was dangerousness. And it was, I mean, who knows which one was, it's a two-legged stool, I guess, at that point, but you need both legs. And so.
Well, I think that if you were to think that the predominant, I think that the fact that it's minority is a necessary reason, because I think you would have otherwise seen out of all 20 states, maybe someone would have said, someone would have said actually 22, because even though they're 21 and they're adults, they're still pretty dangerous at 22 or 25, just like with driving. If it's about dangerousness and maturity to drive, different states come up with different ages. But because the fact that they were children and therefore able to be regulated much more stringently than adults, that's why every single state picks either the word minor or 21. I think that, and I think this tradition of the college in loco parentis rationale supports that the historical tradition is not one of regulating based on age-based dangerousness, because you would expect different states to come up with different ages for that. The DC Council originally thought it was 18, then they raised it to 25. So, legislatures could decide well, does the science really, because it's obviously not binary. I mean, it could be
But I
any
mean,
number of these.
state legislatures decide to restrict alcohol use for under 21. Obviously, there's not an amendment that goes with it, but just in terms of what legislatures can decide makes sense age-wise, 21 is still an age that's in wide use. It even applies to cigarettes, right?
Absolutely. And there's, like, as Your Honor said, there's no constitutional right to drink alcohol or cigarettes, which is why you can regulate that much more,
Yeah, but I made that side point, but my point doesn't depend on there being a constitutional right to it. It just, because you're speaking to the sort of acceptance of 18 versus 21 as an age in current times that informs our analysis as being dispositive in some sense as to what is widely in acceptance as people having reached an age of ability to make their own decisions and control their own decisions and all of that type of stuff. But obviously, it's not just 18 because we apply 21 to things that are perfectly legal for
Right.
everyone else, alcohol and cigarettes.
So I don't mean to say that there's some universal age at which people get to make their own decisions about everything. But the age of majority doesn't mean that you get to do everything, because like you said, you can turn 18 and still not be able to drink. What the age of majority means is that your parents don't control you anymore. And because children are always under their parents' control, that is what justifies restricting their rights, in part to protect the parents' ability to control their children.
Ms. Wang.
And in part because they are.
Interject
Yes.
a little bit, because I'm still trying to make sure I'm following the gist of your argument. And one of the cases that I found persuasive was National Rifle Association versus Bondi. It's a 2025 en banc decision from the 11th Circuit. What's wrong with the rationale in that decision, which I thought was very compelling, perhaps in some of the other circuit decisions that weren't en banc? And it's recent, so it may have come out after you briefed, but they seem to walk through issues about age-related restrictions and guns and minorhood and adulthood and trace back through the founding. And if you want to address it on rebuttal, that's fine with me. But
Yeah, I'm sorry, Your Honor, that I'm not intimately familiar with that case, but I would just say that I don't think any of the cases, I think, recognize that the why of these historical regulations on minors were intimately and integrally tied to their status as minors. And what distinguishes a minor from an adult, again, is their lack of ability to sort of be in control of their own lives. So for example.
But they're not in control of their own lives because they can't be trusted to make decisions responsibly.
Right, exactly.
And at the time of the founding, you couldn't be trusted to make your own decisions responsibly until you were 21.
Absolutely. And but now you can. You not only can you can, run for office, you can be conscripted to the military and use guns to die for your country. I mean, this country has changed, just like handguns are now. It didn't used to be so scary, and I mean, I guess it's still scary, but it used to be so rare and unusual and unlawful, and only, criminals would use handguns. And then this country has changed. Handguns are, that's just what people use to defend themselves. And the country has changed.
How much does this framework under Bruin, Rahimi, this new framework, allow us to take into account those changes? So on the one hand, I am understanding your argument to be that under prong one, here, Mr. PICON is of the people, and his right to own and use a handgun is one that was contemplated under the Second Amendment. So we get past prong one. It's prong two that I'm not sure I'm quite following. Is your argument that because you do not see a straight line of restrictions on gun ownership and use going from the present back to the founding time? Is that your
That's not my argument.
Okay.
My argument is that Bruin requires you to look at whether the historical analogs are relevantly similar in the how and the why. And the why for restricting minors does not apply to restricting adults. And as for when you asked, does the Bruin framework allow us to consider modern circumstances? It not only allows you, it requires you. So Bruin.
You're saying the why, and maybe that we see the why as different, but you're saying the why is we have to have a belief that minors are inherently incapable of understanding the dangerousness of weapons, or are you saying that the why is the dangerousness of the firearms and weapons?
No, I think the why is that minors have diminished constitutional protections because they are always living under the control of someone else already. And that is why, for example, a college can step in as the parent and regulate them as though they were the parent. The parent has basically complete control over their child.
But that
And so-
why was a secondary why that followed from a first why, which is that they were incapable from prefrontal cortex reasons from making these decisions, these weighty decisions, and they were dangerous. I think Blackstone used the word dangerous. And all sorts of other synonyms for that. I mean, that's what led to, the fact that they were under the control and care of their parents was a result of that sort of physiological fact, which is certainly up for debate, but I don't even think it's up for debate in the DC Council under IRA. But so the fact that they're under the care and control of their parents is only part of the equation. The fact remains that they're considered dangerous and incapable of making clear and wise decisions. Prudent decisions, I think, was one of the words that was used back then. And you haven't explained to me why that has changed. And you're linking it to the word adult. But adult is a word without a meaning unless we ascribe one to it. And you're ascribing it to 18 and the other side's ascribing it to 21. And it could mean all kinds of things.
Well, the law gives it a meaning and.
Well, not for all contexts, right?
No, but and I will probably be able to find it. I think it's Rocky Mountain gun owners. Yes, Rocky Mountain gun owners, which is one of the cases cited by the government, that that court cites an early American dictionary which defined minor as follows: a person of either sex under age, one who is under the authority of his parents or guardians and who is not permitted by law to make contracts and manage his own property. And, and then it says, but at that time it was 21, but that's sort of, it could be any age. The actual legal definition is about whether you're under the authority of your parents and guardians. And under DC law, you're not under the authority of your parents or guardians after you turn 18. This says age was defined, this is an 1828 Webster dictionary, as the period when a person is enabled by law to do certain acts for himself or when he ceases to be controlled by parents or guardians.
No, but what I'm saying is skip first prong. We're in the second prong. And the question is, was there a determination in the 1790s that people 18, 19, and 20, forget the word adult, forget the word minor, 18, 19, and 20 lacked the wherewithal to responsibly own or possess a firearm? And at least one answer is yes. And I think you've probably conceded that. I think that certainly that was some of the historical tradition. And you're saying that today, that's no longer the case.
That's
But
not what I'm saying.
because
I'm not saying
people
that.
18, 19, and 20 are now called adults. And I'm not sure how that follows.
Okay, I'm not saying that sort of the intuition about brain science has changed. I guess, they obviously didn't have brain science back then, but they understood that young people are more irresponsible. And of course, that holds true today. What I'm saying is that they thought back then that, there's lots of irresponsible people. You could think that, or dangerous people. You could
Right,
think.
and Supreme
and-
Court has said we can regulate
And
them.
exactly,
with
and you
respect
could
to
think that,
firearms.
men in their midlife crisis are irresponsible and risky and you want to regulate them. Or you could think that people over the age of 60 have experiencing cognitive decline. We should regulate them. But there is no historical tradition for regulating them because they're adults.
Well,
And I,
this is why I raised the Bondi case, the national, if I could just read something briefly from, this is National Rifle Association v. Bondi, 11th Circuit en banc decision in 2025, and it says, we draw two lessons from the legal treatment of minors at the founding. First, minors generally could not purchase firearms because they lacked the judgment and discretion and to contracts and to receive the wages of their labor. Second, minors were subject to the power of their parents and depended on their parents' consent to exercise rights and deal with others. Then it goes on to say the law of the founding era, which restricted the purchase of firearms by minors, continued into the 19th century in the form of statutory provisions, which restricted the purchase or use of firearms by minors. And so it seems like this rationale combines both your argument about the control of their parents, but also recognizes this direct line of restricting minors' use, ownership, possession of firearms from the founding period to the present. And so you're shaking your head, but yet your argument seems to disagree with this.
well, I am not going to, let's just assume that there is a founding tradition starting from 1791 to today of restricting firearms of minors.
Mhm.
Okay. My point is that we have to look at what minors are today and not what minors were in 1791. Just like we have to look at what unusual and dangerous and weapons were, which is under the second prong of Bruin, by the way, or sensitive places. That's an even better example. So Heller says there was a historical tradition of regulating firearm possession or carrying in sensitive places. But that doesn't mean that we are only limited to what the founders thought were sensitive places. We look at what today we think of as sensitive places. And so under the second prong of Bruin, under the history test, you have to look at what the modern conception is that fits into the rationale of the original.
But you're speaking to factors that actually increase the scope of regulation that cut in the other direction. So as
Not
opposed,
necessarily.
well, if we increase the number of arms that can be regulated and the number of sensitive places that can be regulated,
You could decrease them too, based on modern conceptions.
but not below a floor, right? And so if the floor under the historical tradition is people who were not deemed fit to possess firearms, then why can't we continue with that floor today?
I don't think that Heller was saying that if something was considered sensitive during the founding era, it has to always be considered sensitive, even if today we no longer consider it sensitive. I don't think it was a one-way ratchet. I think it's a two-way ratchet. It means that we look at what's sensitive today, just like at the time of the founding, there was a restriction. If there were restrictions on handguns as unusual and dangerous weapons, we're more protective of the right today than we were back then. So I don't think it means that there's a floor and you can only sort of increase regulation. What Heller is saying is that you look at the category, the principle that's drawn from the historical regulation. Okay, there's a principle in historical tradition of banning dangerous and unusual weapons. And then there may be some collection of weapons back then that was, the Bowie knife and whatever. But if they're in common use today, they can't be banned on that same rationale. And the same is true, I think, of any other type of regulation. If you look at, restrictions on minors, that rationale doesn't justify a restriction on people who are no longer considered minors. And I want to say something that, I understand that, Judge Schenker, that you're obviously very skeptical of this idea, but I do want to point to another way that the government's analogs are not relevantly similar, which is that all of those restrictions were on a narrow class of weapons. It was not all firearms. And so that is a very significant distinction in the how. The how at the time was to restrict young people, minors, from having this dangerous and unusual class of weapons. that people, and it was actually to criminalize people supplying them with those weapons.
Well,
What we have
according to-
today
According
is-
to Bondi, it was all firearms.
I'm sorry?
According to the Bondi rationale in the Bondi decision I just read, they view the founding restrictions through the present with respect to minors to be with respect to all firearms.
Well, I think there's nothing the government has cited to this court today that says all firearms. Everything that they've cited, the only thing that they've cited as to all firearms is the college campus ones, which I think are sort of even more explicitly tied to being in loco parentis. But apart from those college campus rules, which again are about college campuses, not about any time you step outside your home or even inside your home, every law that I've seen them cite is limited to, does not apply to rifles and shotguns. And so in the 1860s, you could be a child, a 20-year-old considered a child and be absolutely free to carry, or someone could give you or sell you, and you could carry a rifle or shotgun for self-defense or hunting outside the home. And to say that this limited restriction on a narrow class of unusual and dangerous weapons justifies completely disarming.
Well, so you and your co-counsel seem to be trying to have it both ways, because the government has pointed on the other end of the spectrum to broader regulations that said, and I'm paraphrasing wildly here, but people under 21 can't do, as I think I put it to Mr. Kaplan, A through Z, right? And it wasn't tailored to firearms. And you seem to be saying the fact that, it wasn't tailored to firearms means it's not a close enough analog. But then you're also saying they were too specific in what they regulated. So.
Yes, and I think the difference is that the Bruin test specifically says that the government bears the burden to show that the challenge regulation is consistent with the nation's historical tradition of firearm regulation. I mean, that's the test. So you look at the firearm regulation and Bruin tells you, you have to look to see whether it's relevantly similar in how and why. And it says if something is regulating, is trying to target the same government interest, dangerous young people, but it burdens the right much more greatly than the one at history, then that would suggest it's unconstitutional. That's what Bruin says. So maybe, the reference to children couldn't do all sorts of things, that gives you a background understanding of why legislatures were regulating children so heavily, because they thought they could, because they didn't have the full legal rights of adults. That gives you background understanding, but that's not what the Bruin test asks you to look at. The Bruin test asks you to look at the nation's historical tradition of firearm regulation. So that's the reason that there's a distinction there. I do want to get to, we've been focused on the government.
I would note, we're way over your time, and
Happy to
we've
sit down
asked
if
you
want
many
to.
questions, so it's partly our fault, but.
Can I ask one? Sorry,
Yes.
Hopefully a quick answer. I think you, I don't want to say conceded, but you agreed that the 1850 Reconstruction era laws might be relevant to some extent. So are you, do you agree that the footnote in Ward, which is arguably dicta, but are you not relying on that?
I think everything that Ward says about the Second Amendment is dicta.
All right, thank you.
Good morning, and may it please the court, Eric Hansford for the United States. As I think we've heard this morning, the question in this case is not whether the Second Amendment permits age-based restrictions. I think everyone agrees, and all courts have agreed, that the government has the power to restrict a 13-year-old from carrying a firearm. The question instead is where the Second Amendment permits the government to draw that line. And the line that the DC Council chose is the traditional historical line, which is age 21. That is the age at the founding where all sorts of rights were generally limited and then were specifically limited as to, or in a way that specifically limited access to firearms.
Now, Mr. Kaplan says in his argument that it was 18, that 18-year-olds were allowed to possess and carry firearms. You're saying 21. How do you account for that?
So I think Mr. Kaplan is citing the militia practice, which I think as to the militia practice, I think there are a number of reasons that is not informative here. I think we agree at a broad level, and as to the militia practice, that the Bondi opinion, the en banc decision from the 11th Circuit is instructive here, is probably the cleanest way home following that reasoning. And as to the militia practice, it explains first that Heller specifically says the militia clause doesn't expand or limit the individual right, and also that it is recognizing an individual right unconnected with militia service.
So how do you get the 21-year age for individuals at the time of the founding?
So that comes from the treatment of infants at the time of the founding, what were termed infants at that time. Anyone who was under age 21 was termed an infant and didn't have a whole variety of rights, didn't have a right to petition, to vote, to contract, and not only were their general rights limited.
But it didn't specifically talk about the right under the Second Amendment to have a weapon, bear arms.
It didn't specifically talk about firearms, but as the Bondi opinion goes through, all of those limits severely restricted the ability of anyone who was under 21 to access a firearm. And then when the issue became presented in the 1800s as to firearm specific restrictions, those statutes in the 1800s, numerous states and Congress drew the line at age 21 and said you can't give a pistol to anyone who is under age 21, which is exactly the line that the district is drawing today.
So let me ask you, would you agree that but for the 14th Amendment, that there would be an argument, obviously not one I'm espousing, but there would be an argument that the government, but for the 14th Amendment, maybe that's your answer, could constitutionally restrict the right of Blacks to own firearms?
So I mean, we certainly agree that the 14th Amendment does work in terms of preventing a lot of the sort of discriminatory, obviously odious sorts of restrictions that were being imposed at the time of the founding, and that the Equal Protection Clause invalidates a lot of those.
So would the Equal Protection Clause do the work for, let's say, wealthy landowners?
In terms of invalidating something that's limited to wealthy landowners, my understanding is that it's not clear those restrictions were actually being imposed at the time of the founding, that it was limited to landed in how I'm understanding.
I mean, maybe it goes to the first prong, because the lack of restrictions would seem to be analogous, to use the term, to what you're arguing with respect to people under 21, because there aren't really on point restrictions under 21. There was the more overarching sense that they weren't entitled to the rights of the Second Amendment, again, whether it's under the first prong or the second prong. So that would seem to apply just as well to wealthy landowners at the time.
So I apologize, I'm forgetting the case. I think it's Bondi, but one of these cases discusses how already at the time of that founding, those sorts of restrictions on landed versus unlanded were kind of melting away. So I don't think it's clear those would have been established in the same way infancy was at the time of the founding. But we agree that there are a lot of stickier issues to address if you are at step one, if you are at the people argument, and that the far cleaner way of looking at this is to look at this at the step two restrictions of what historically was permitted. And going to Judge Schinker's point that you were making during the argument, we agree that the notion of adult or of the age of majority isn't kind of an abstract concept in that that makes sense without attaching rights to it. Instead, we ask right by right, what is the age at which we attach rights? And I think indicative of that is 2 months after the DC Council passes the age of majority, it passes these same firearm restrictions. So in other words, it is simultaneously saying those under age 18 have the right to contract, to join a profession. We cite this case, this court's decision in Tucker on page 24 of our brief that recognizes some of the points that the age of majority act does expand to those who are between 18 and 21. But at the same time, the DC Council is saying that is not extending the right to possess firearms.
Is there a meaningful distinction that we should make? Bondi seems to be a pretty comprehensive and thoughtful opinion of the en banc 11th Circuit, but that was a purchase, right to purchase. Is there a meaningful distinction between the right to purchase a firearm and the right to possess it, in the home and versus the right to carry it outside of the home?
So, I mean, there is a separate federal statute that bars the right to purchase for those under 21. So we do think that separate federal statute stands on even firmer footing, but we think the Bondi reasoning indicates not just that there was a lack of a right to purchase, but there was a lack of access to firearms at the time of the founding. And insofar as that's murky, that gets liquidated and clarified by these 1800 statutes that the defense is recognizing can clarify. And I think it's important to say those didn't just go unchallenged. Instead, the sole decision that did challenge it, which was from the Tennessee Supreme Court, said that is a permissible, that is constitutional, upheld that provision, even though the Supreme Court of Tennessee at that time was otherwise following the view of Heller as to the individual right to self-defense. And indeed, Heller specifically upholds the Tennessee Supreme Court decision on that score.
So the chief judge asked counsel on the other side to, grapple with Bondi. Bondi and Rocky Mountain are both sort of the federal court of appeals cases that support your position. They're both purchase contract cases, and I understand that you've explained why you don't think that's pertinent, but I would just ask you then, as a counterpoint, to distinguish Reese and Worth and the Pennsylvania case.
So just initially, I would add in the First Circuit's decision in Renee E. into that mix. It's a 2009 decision, but it is squarely based on history. It is not a kind of step two means end scrutiny. And as I think the Fifth Circuit decision that we rely on in NRA v. ATF explains, that later gets overruled, but it explains that the reasoning in Renee E., even though it addresses those under 18, applies equally to those under age 21. It's talking about how at the founding, this is the treatment of those who were infants and these 1800 statutes. So I would just add that case into the mix. In terms of the other cases, I mean, we view Bondi in particular as the most comprehensive, thoughtful analysis of this issue. And it has a lot of historical explanations that are not covered in the earlier cases. And I think a lot more nuance in terms of how it is that at the founding, the general restrictions on rights, for example, the right to contract, would have specifically applied in a way that limited access to firearms. And that's something that we think Reese in particular fails to understand, but the other cases as well. The Worth decision, I would say, in addition, seems to fail to grapple with how Rahimi clarified Bruin. Worth is really looking for a historical twin, as are, I think, Laura and Reese. And then the other point I'd say on those is Worth, Laura, and Reese are very focused on the step one, who is part of the people, are 18 to 20-year-olds part of the people. But at step two, they fail to return to the founding era treatment of those who were infants and fail to say, even if 18 to 21-year-olds are now part of the people, 18 to 20-year-olds, does nonetheless the treatment at the founding of those who were infants help to justify these sorts of restrictions. They never even address those issues. They also give short shrift to the 1800 statutes. They largely dismiss those on the theory that they come too late. which is inconsistent with Heller and Bruin. And again, is a situation where we think Bondi is especially instructive. Judge Newsom concurs in Bondi and says, I am especially skeptical of using post-ratification history like these 1800 statutes, but in this specific context of age-based firearm restrictions, it actually does make sense and helps explain why there would have been silence as to firearm-specific restrictions at the time of the founding, and avoids the mistake that Justice Barrett warns about of taking silence as a signal of a lack of legislative power.
So I don't think the time for filing cert in Bondi has expired, if I'm.
I believe there has been a cert
There is
petition
a cert
filed
petition,
by
okay.
the NRA in that case. So I believe there is a pending cert petition in that case. I believe the government has obtained repeated extensions of a cert petition in the Reese case. So I don't know if there's going to be a cert petition in that case. But it is certainly possible that this would be going to the Supreme Court at some point. The one other point I wanted to address was PDS's suggestion that pistols at the time were dangerous and unusual weapons, and that's why they were being restricted. That is very much in conflict with how Heller and Bruin are treating pistol-specific restrictions. Instead, they say there haven't been restrictions on pistols, on all carrying of pistols in the way that was at issue in Bruin. And specifically, they cite a Georgia Supreme Court case and a Tennessee Supreme Court case that are striking down restrictions on all carrying of pistols and are limiting those restrictions to concealed carry. And so you would have had pistols been dangerous and unusual weapons in the 1800s, those restrictions should have been upheld. And instead, what we have is the 1800s courts are striking down those restrictions, suggesting that they're not dangerous and unusual weapons. And instead, the reason these are being restricted is because of the age of 21. If there are no further questions, we'd ask this court to affirm.
Great, thank you. All right, Ms. Van Zyl.
May it please the court, Caroline Van Zyl on behalf of the District of Columbia. There are 3 points that I would like to make in response to the discussion that has occurred so far today. The first is that the absence of a firearm-specific statute in 1791 is not definitive. The second is that the age of majority for other rights is not dispositive of how we should treat the Second Amendment right. And the third is just to emphasize how broad and deep the historical tradition is here, and that same tradition endures to this day. And so
Historical tradition of regulating.
So here's how I would put it, of restricting access to firearms based on age for those who lack the judgment and discretion to use them safely. I think that is the principle that we see from the founding at common law, even if in that context it wasn't necessarily firearm specific, stretching into the 19th century and then continuing through a consensus of the states and federal government to this day. And so turning first to the state of the law in 1791. Now, it is true that we have not located a firearm-specific statute governing this age range at the time, but that is not dispositive because the common law, as we've discussed to a certain extent today, and as the court in Bondi, I think, very well captured, the common law was the primary source of law at the time of the founding. Statutes, in fact, were just relatively uncommon up until the mid-19th century. And so when we have evidence that the common law, as a practical matter, all but prohibited individuals in this age range, 18 to 20-year-olds, from going out and independently obtaining firearms, that's a very meaningful piece of data that I think many of the courts who have gone in the other direction, in Reese and Lara and Worth, all but ignore. And I think that is a
But
tremendous
wasn't the
mistake.
common law bar or preclusion of the ability of that age range to procure firearms based largely on their inability to contract?
It was based largely on their inability to contract, also their inability to make their own wages. Their wages were then transferred to their parents. But I don't think the fact that it operated slightly differently is dispositive in this Bruin analysis, especially when you're at step 2, because what it meant was that these individuals just couldn't go out on their own and access firearms. And I think when we're doing this analysis, the whole point is to understand what would the founding generation have understood to be the contours of this right. And I think it's very odd to imagine that the founding generation would think that 18 to 20-year-olds had a fundamental, unabridgable right to bear arms when they can't even go out and obtain them on their own, when they're completely dependent on their parents, on the grace of their parents to be armed or not. It just doesn't make a lot of common sense in terms of how that understanding would play out. Add to that the fact that they could not go to court on their own to vindicate any supposed right to bear arms at the time. They needed to act through a guardian or a best friend. And I think it paints a fairly clear picture of how strange it would be to assume that the founding generation would believe that these individuals had some sort of sacrosanct right to own, to keep, and to use guns. And then, even to the extent that you think that there is some ambiguity there, that's exactly the situation, as my friend representing the United States has said, where you want to go ahead and continue looking at the trajectory. And so then you get to these 19th century laws, which impose some very robust restrictions, again, on the ability of 18 to 20-year-olds to obtain firearms in any way. By the end of the 19th century, 19 states and the District of Columbia had bans on purchasing for those under 21. Most of those states prohibited all methods of conveying these kinds of pistols to those under the age of 21. And only very few, I believe around 4 of those states, had an exception that would even allow parents
So
to
what do we
convey
do
arms to their
with
children.
Ward and its footnote? Do you agree with your friend on the other side that it's dicta?
We do agree that it's dicta. I mean, and in particular, the logic of that footnote was that somehow the district would especially be tied to the history of 1791. And we know from Bruin and McDonald and Ramos and other cases that when it comes to the Bill of Rights and even the Second Amendment in particular, the scope of the right is the same as to the federal government and the district and as to the state. So we think that, as the court put it, the Second Circuit put it in Antonyuk, both eras are fertile ground, especially when you see this historical consistency. And I would
What do you
note
make
too
of
that
the district's exception for those between 18 and 21 to be able to have access to a handgun with parental consent? Ms. Wing argued that that doesn't really go far enough because that access with parental consent would only be within the home and not a right to carry outside the home.
That's correct. That exception covers registration, which allows you to own a firearm in your home. But I would just note that the district is by no means an outlier in prohibiting concealed carry for 18 to 20-year-olds. By my count, certainly over 30 states have similar restrictions. Around 7 states have similar outright bans on possession. And so I don't think that there's anything particularly unusual or remarkable about the district saying, look, unless you're serving in the National Guard or in the military, you can't concealed carry outside of the home. It's relatively commonplace, and it mirrors many of these, again, 19th century regulations, which also governed concealed carry. So I agree with the description of how the law works, but I do not agree that that is in any way, shape, or form a problem. The other thing to note about the absence of a positive statute at the time of the founding here is that one would not expect to see a statute in that firearms violence was not really a social problem at the time of the founding. I mean, to be sure, there were weapons, there was violence, but firearm violence did not emerge as a major social problem until the 1850s. That is when firearms became more lethal by some scholars, estimations 10 times more lethal over the course of the 19th century, more concealable and more broadly available because of the advent of mass manufacturing. And you add to that the fact that children's relationship to the economy and society really changed at that time as well. When you look back to the founding, it was a largely agrarian society. There's very close parental supervision. Whereas by the time you get to, say, the mid-19th century, you have firearms becoming more lethal, and you also have more 18 to 20-year-olds going into cities to work at the mill. Suddenly they're able to keep some of their own wages so that they can purchase these firearms. And what happens is suddenly youth firearms violence becomes a real problem. And that's when legislatures step in to regulate. And that's when we should expect them to step in to regulate,
Is there
right?
any analog to that in modern times in DC? Youth firearm violence?
Youth
here?
firearms violence, certainly it remains a problem to this day. And that's part of the point I'd love to emphasize about the broad and deep nature of this tradition and how it endures to this day. Firearms violence for this particular population remains a very real problem. 18 to 20-year-olds are 3 times more likely to commit homicide than those over the age, at the age of 21 or over.
But I mean, all of that is probably beyond dispute, but it seems to point to a problem with the Bruin test, which, I mean, who are we, anyone in this room to question that now? It's established law, but there seem to be very few of these Bruin cases where anyone has really pointed to a clear analog from the 1700s. And I'm finding it hard to see how you will continue to be able to justify various firearm restrictions beyond the general point that there simply was no need for restrictions back then, and there is now. That seems to take yourself outside of the Bruin framework.
Well, I don't think it takes us outside of the Bruin framework. I think in general, when you have societal developments that represent major changes, you do apply a more nuanced approach. Now, I don't think the court necessarily needs to get into that here because we do have these common law analogs that we think we agree with the court in Bondi that very much, furnish what we need for purposes of 1791. My point about the changes that took place during the 19th century and how things might be different today is largely to speak to, one, why we might not reasonably expect a statute as opposed to the common law at the 1791 period, but it also, I think, goes to the why. I think this is how these sort of statistics and validation that this population remains dangerous is still relevant. If we're at step 2 of Bruin, we're looking not at just at the how of the regulation, but at what motivated legislatures or those who expounded the common law to regulate at the time. And again, as we expressed in our brief, we think that that goes to dangerousness, specifically the fact that age can mean that one lacks the judgment and discretion to use a firearm safely. We think that that was the judgment of the founding generation. We have quoted to you in our brief discussions from Governor Morris, John Adams, Thomas Jefferson, talking about the lack of judgment and will. Blackstone classed infants with, and I'll use his language, although I do not like his language, with idiots and lunatics, as a group that lacked discretion and hence could be particularly dangerous. And again, I think in this context, we do have common law analogs. To be sure, they're not twins, but as the Bondi court found, they're certainly analogous enough to uphold our restriction, which has exactly the same aim, which is to disarm those who are especially dangerous because of their age. And then the last point I'll make is just to go to the age of majority point, since our friends at the Public Defender Service seem to think that the case rises and falls with the age of majority. But I don't think that that can possibly be right. Among other things, the court, I think, rightly said in Polis that there is no one age fits all standard for rights. Different rights have always been actualized or inherited at different ages. That goes back to the founding when you could form a marriage contract if you were a boy at age 14, for girls at age 12, whereas other property rights weren't actualized until the age of 21. And as discussed, it continues to this day when certain rights, like the right to drink, although not constitutional rights necessarily, or the right to access tobacco, are still set at age 21. And again, coming back to some of those statistics, you have more than 30 states in the federal government, all in broad accord, even after the passage of the 26th Amendment, saying that 21 is the age at which individuals have enough discretion to be safe, to be non-dangerous with the unsupervised use of firearms. And so particularly given the depth and breadth and duration of that tradition, we think that the district's firearm regulations here are certainly constitutional. I'd be happy to answer any further questions, but if not, we would ask that you affirm.
Great, thank you. Mr. Kaplan, you reserved a few minutes for rebuttal.
Thank you, Your Honor. I'd like to discuss just briefly the case that you mentioned, Bondi, Your Honor, because I think the reasoning in that case actually supports our position. I think, first of all, the case was wrongly decided, and I think the dissent has the better argument in that case. I mean, the line of reasoning in that case was that people in the founding era, young people in the founding era, could not purchase firearms because there were restrictions on their ability to contract. But that's true. There were restrictions on their ability to contract. A contract by someone under 21 at that time, as is the case now for people under 18, was voidable. But that doesn't mean they didn't, as you know, my kids certainly bought lots of stuff when they were under 18, even though I think in theory, those contracts were voidable. And as the dissent points out, there is actually affirmative evidence that minors at that era did buy firearms. But setting that aside, the fundamental point of that case was that there's a tradition supposedly of minors not being able to buy firearms. And therefore, because that tradition of minors not being able to buy firearms, we can accept the law that says minors can't buy firearms. But the case emphasizes that it's not a restriction on the possession or ownership of firearms, as the DC statute is. And obviously, there was no prohibition on possession and ownership. There was actually an affirmative duty under federal law to own firearms.
The DC statute we're talking about isn't a prohibition on possession or ownership. It's a possession on carrying outside the home.
Well, I think
I mean, I still understand your point, but I think you stated it a little more broadly.
yeah, but the other statute, the registration statute, would actually prohibit ownership unless you somehow got a parent or guardian to sign for you.
That's not what your client was convicted of.
No, he was convicted of that statute. And that's that.
I guess it was, yeah, it was UF and UA. That's right. Okay.
Yes, and both statutes. And the other, you know, also the other case, which I think the recent case where the government looks for support on, the Paulus case, again, that upheld a ban on the sale of firearms. In fact, they stopped at the first step. They made what I think is kind of a questionable determination that the sale, that although possession of the right to bear arms was protected, the right to purchase firearms was not protected under the first prong of the Bruin test. But again, I think the reasoning of both of those two cases, which the government looks to for support, the Paulus case and Bondi case, both of those cases rely on the fact that what was at issue there were bans on the sale of firearms. And I think they would have come out very differently if it had been a statute similar to what's in this case.
Why? How much difference does the sale versus the possession and right to carry make? Because you can't possess or carry if you can't purchase. So
I don't disagree with that, but I think that the reasoning of those decisions did disagree with that. They thought there was a significant difference between purchase and ownership or possession. And it was the purchase, they said there was support for having a prohibition pursuant to the consistent with the Second Amendment. And just very briefly, on this issue of who composes the people, which obviously is a very important issue. the historical test in Bruin is really focused on the second prong, looking for historical analogs. The first prong, history probably has a role to play there, but it's principally looking at the text of the statute, and it's not confined to who the people were in 1791. If it were, again, as we went in our brief, is if that were the case, all sorts of people who we would find it unacceptable to deny rights to blacks, married women, Native Americans, would have no rights. And surely that is not the state of the law, and that's not the way the Second Amendment should be interpreted. Thank you.
All right, thank you. Ms. Wayne?
I want to underscore what Mr. Kaplan just said about Bondi, which I apologize, I hadn't been as familiar with it until just now, but Bondi draws the historical justification for the Florida prohibition on sales of pistols to the fact that at the founding, minors couldn't purchase anything. And so they say, of course, they couldn't purchase firearms because they couldn't purchase anything. And then it looks to the regulations from the 1800s that the government cites in its brief. And so it says that, the law about prohibiting sales is justified by this historical tradition. And I think that, of course, children, if they can't purchase firearms, doesn't mean that they can't carry them if their parents purchase them for them. And so I don't think there's any evidence that at the founding or otherwise, children whose parents purchased firearms for them, for hunting, for self-defense, or anything else, could carry them. And there's just not the same historical traditions starting from the founding until today that justifies this law the same way that it did in Bondi. That's number one. Number two, I think Bondi sort of does the same thing, uses the same argument that the district just articulated, which is sort of the age of majority isn't the same for every right. And that is not what we are trying to argue. We're not saying that the right to carry a firearm has to be tied to the right to vote or any other particular right. What we're saying is that the rationale at the founding and the rationale for restricting the rights of minors stems from the fact that their legal status is one of being controlled by their parents. That's the definition of what a minor is, and that's what Rocky Mountain Gun Owners says. It's not, a minor isn't defined by whether you can vote, whether you can drive, whether you can drink, whether you can serve on a jury. A minor is defined by whether you're controlled by your parents. And that is, I mean, if you're a child and you're controlled by your parents, you live with your parents, you can't own your own property, then you depend on your parents to defend you.
I think you went around this block with Judge Schenker and with me, being a minor is defined by the fact that you're under 18. And one of the consequences of that is that you're under the control of your parent and other things. But
Yes,
I thought we'd
well, I
covered this
think
ground.
that the law states the age at which you become an adult, but I think the significance of becoming an adult that we're trying to emphasize is that once you become an adult, it's not that that it means you can do all these other things. You can vote, you can, serve on a jury. Those are important because they sort of recognizes society's expectation that you are, a participant of the political society. But what I'm saying is significance about turning 18 or today or back then turning 21 is that means that your parents don't control you anymore.
Is there, as you describe and define minor, someone who's controlled by their parents, is there anything underlying that related to the cognition, the judgment, the maturity or developmental aspects of a minor?
I mean, I'm sure there is, in the sense that, just from a factual standpoint, that's not exactly why the age was lowered to 18, that was a political decision because people were drafting children, 18-year-olds, to go die in the Vietnam War. And they thought, well, why can't we be adults then? But sure, that is
some sense of a need for a person at a particular age that we define as a minor, to need some supervision
Yes.
because of their maturity level, judgment, whatever.
of course.
And that theme runs through to the present and is, at least in part, the government might say large part, what underlies the basis for an age-based restriction on people of a certain age not being able to own, use, possess, purchase firearms.
I guess what I'm saying is that once society has decided that an 18-year-old is mature enough to not be controlled by his parents anymore, then the government can't regulate his constitutional rights as easily as they did when.
But society could determine that someone under 21 should be under the control and care of their parents with respect to certain things, right? I mean, obviously.
That's not what this law does. This
Well,
law does
no,
not make, this law is saying the government makes it a crime for you, even if your
No, but
parents have.
what I'm saying is, your point is that the justification is care and control and custody of your parents, which is important for whatever age it is that you're focusing on. And I'm saying that society could still determine that that should be the case. In other words, the justification for a firearm restriction for someone under 21 with respect to firearm restriction, not with respect to voting, with respect to drinking, not with respect to serving on a jury, with respect to cigarettes purchases. So what is it that turns on 18? I know we're going back over.
Right. What makes the firearms possession and carrying different than voting and on a jury is that it's protected by the Second Amendment. And the Second Amendment test tells you that you have to find a historical analog that's similar in how and why. And the historical analogs are all about, preventing the purchase or acquisition of firearms by minors who couldn't purchase or acquire anything on their own.
No, but the why you said is that you should be under the care and control and custody of your parents. And at the time you agree that it was under 21. And I'm asking what stops society from determining that for purposes of firearm possession, that age at which you should still be, and I realize most people aren't, but should still be theoretically under the care and control of custody of your parents, is 21 still for firearm possession. And it basically is for alcohol possession. We're outside of the constitutional realm. I'm just saying in terms of the wisdom of a judgment that 21 is an age that is relevant for certain purposes. It is still a legitimate judgment. It can be a legitimate judgment as to certain items and products and activities, and not as to other items, products, and activities. So what's wrong with that judgment by the legislature?
I'm not saying that the legislature can't make those judgments. I'm just saying that the Second Amendment requires the government to justify that judgment with history and tradition that is relevant in how and why. And then I also, this is actually from Bondi. Bondi quotes the Supreme Court saying that the Supreme Court has recognized that even when there is an invasion of protected freedoms, the power of the state to control the conduct of children reaches beyond the scope of its authority over adults. It's quoting Ginsburg versus New York. So there's this background principle that the government can control the rights of children more than it can of adults. And that when society recognizes that 18-year-olds are no longer children, that they're adults, then that rationale for controlling children from before doesn't translate into controlling them now that they're adults. And that's our basic, simple point.
All right, thank you.
Thank you.
We'd like to thank counsel for all of your excellent briefs and arguments. Amicus, counsel for appellate, government, United States, and our DC Attorney General's office, and we'd like to thank all of you for your stamina in remaining with us for these arguments today.
This court is now adjourned.